exact moment he walked up, but generally I was looking over some notes or thinking about the extent to which women could succeed in areas of violent crime, in law enforcement. There had been some rumblings in Santa Monica, where I lived, about a particular woman officer who was incapable of performing some acts, and I was writing or thinking about that.
So you expressed to him your interest in writing about women who are employed as police officers.
Yes.
And he indicated to you that he had some strong feelings about that subject?
Objection.
Sustained.
What did he respond?
It was around that time that he told me he was an officer and had strong feelings about whether or not women should be on the Los Angeles Police Department and working specifically in areas of high crime.
Did he tell you anything about any organization he was active in with respect to that issue?
Yes, he mentioned Men Against Women, which is actually policemen against police women, commonly called MAO.
Now, as a result of this conversation, did you agree to have further conversations with Officer Furman?
Yes.
How did that come about?
After he told me about this particular group, Men Against Women, it stirred a curiosity, and I was very interested in finding out why a group like that would be formed, what kind of frustrations some men working on the police department would have that would cause them to want to join a group like that, and what kinds of things they would do to stonewall or embarrass or humiliate women, and also what kind of effect that had on women, how they would feel. So I thought that that particular issue was something that I really would like to explore, and I would very much like to have his point of view as to why some men felt very strongly that some women were incapable of working in areas of high crime.
Now, is this a frequent or common arrangement when someone is doing a screenplay or preparing a treatment for a screenplay to consult with someone with first-hand experience?
Objection. As soon as fast, I'll go.
Oral. Do you understand the question?
Yes, I do. Thank you. I work that way. I don't know how frequently all writers do. I would think frequently. You really need, if you're going to write about a particular issue and you want to be able to obtain different points of view, then you need to talk with people who have that kind of experience, and you also need to be able to understand procedural issues in many different facets. So it's a very common practice for me. I do extensive interviews and with people, and I shadow them with their permission at work just to see what kinds of obstacles they have during the day, who their friends are, what their conversations are. So it's a common practice with me.
All right. And was Mark Furman the only person you were meeting with or consulting in the course of preparing this treatment?
Sustained.
At the same time, well, let's start with Officer Furman.
I'm still at the cafe in Westwood.
Okay. Did you agree at the cafe in Westwood that you would continue to meet with Officer Furman for purpose of getting this background information that you wanted?
Yes.
How soon after your initial meeting did you first sit down and talk with him in an interview format?
In early April.
Now this interview, where did that take place?
We usually met at Alice's restaurant in Westwood. I believe it's on Westwood Boulevard.
And again, briefly describe your purpose in having this meeting in April at Alice's restaurant.
I needed to hear his ideas, his thoughts, his feelings about some elements of police work.
Did you tape record that interview?
Yes, that initial interview, a taped interview in April, was taped. I believe that was April 2nd.
Okay. Now, this, I take it, was the first of a series of interview meetings. Is that correct?
Yes.
About how many times did you sit down and conduct an interview of this nature with Officer Furman?
Approximately 12 to 15 times.
And were all of these interviews tape recorded?
No.
How many of them were tape recorded?
12 to 14. One in particular I remember that was not tape recorded was one in 1993 with then, I believe, Detective Furman, a gentleman who had optioned the property, and another woman officer that had been who had been a partner with Detective Furman.
Okay. But your general practice was to tape record the meetings between yourself and Officer Furman.
Yes.
What was your purpose in tape recording them?
I knew that it seemed to me that he would be giving me a lot of information that would be hard for me to process because it's new. And I needed to hear his words for dialogue purposes to be able to construct accurate characters so that they would be clear. And I needed to, if it was a police procedural issue, I would need to listen to it again and be able to visualize it, to be able to cinematically write it. And I didn't feel that I would be able to take copious notes on a yellow pad that would enable me to listen actively, ask questions, participate, take the notes, and then be able to clearly, cinematically write it.
And was Officer Furman aware that you were tape recording the conversations?
Yes.
You just put the tape recorder on the table,
Yes.
turned it on?
I turned it on.
Were there times when you would turn the recorder off?
Yes.
Describe those times.
I didn't automatically turn the recorder on when we would first begin the interview. I would turn it on when I felt that he was ready to discuss perhaps some of the questions that I had given him ahead of time, or he just seemed that it was the appropriate time to start taping.
And were there occasional interruptions with people serving food or things of that nature?
Yes, there were interruptions.
And you would not record those interruptions?
Sometimes I would turn it off if I could see it would be a lengthy interruption.
Now, after you concluded the interview, what would you do with the tape?
I would put the tape in my transcribing machine at home in front of my computer and transcribe the tape. My transcribing machine accommodates transcriptions because it modulates the speed of the tape so that you can slow it down or speed it up to be able to hear more clearly. It also has an audible. It modulates the volume and has a foot pedal to allow you to stop and start and rewind appropriately.
So this is professional transcribing equipment that you use?
Yes.
Did you have some experience in operating that equipment and transcribing tapes?
Yes. I was a professional transcriber in college.
And how long did you do that?
2 to 3 years. I worked for a retail credit company.
And your job at Retail Credit Company was actually transcribing taped interviews?
Objection, please.
Stay.
What were your duties at Retail Credit?
My job was to transcribe reports that inspectors would give regarding people they were investigating.
Now, were the transcriptions verbatim transcriptions of what was on the tape?
My transcriptions were of what Officer Furman would say, what I would hear him to say, and what I would say.
Right. So what you put into the transcript were his words.
Yes.
Did you edit his words at all in the process of transcribing the tapes?
No.
And in fact, did you on at least one occasion tell Officer Furman that the transcripts you were preparing were verbatim transcripts of what he was saying?
Yes.
Now, in these transcripts, or in the interviews that were taped, was the word nigger ever used?
Yes.
Now, if that word appears in a transcript of the interview, is it because that word was spoken by Officer Furman?
Yes.
You never added that word to any of the transcription that you were preparing on any occasion when he didn't say the word, did you?
No.
After you transcribed the tapes, what did you do with the actual tapes?
I put them in a filing cabinet that's designed for tape storage.
And you preserved them?
Yes.
Now, have all of the tapes of all of your interviews with Officer Furman been preserved?
No.
Could you explain what happened with respect to any tapes that are no longer still in existence?
Yes. I inadvertently recorded another interview over one tape and a similar situation with another tape.
So when you taped over, it erased what was originally on the tape.
Yes.
Do you recall which interviews that happened to?
Our first interview, taped interview, and I believe it's numbered the 9th now.
Okay. Now, the first interview is the one you've already referred to on April 2nd, 1985,
Yes.
at Alice's restaurant.
Yes.
Do you recall approximately when the 9th interview was?
I'd have to look at it to be able to tell you.
We'll come back to that. Now, at the time you were preparing what is called a treatment for a screenplay, is that correct?
That's correct.
Could you explain the difference between a treatment and an actual screenplay?
A treatment is a narrative form of the story. It's in prose and in paragraph form. It delineates the principal characters, the protagonist, the antagonist, some of the secondary characters, the main problem in the story, what the obstacles are, possibly some dialogue, what the resolution might be.
And the screenplay that you were contemplating was to be a fictional story, was it not?
It was to be a fictional story based on reality.
Did you ever explain to Officer Furman the role he would play in terms of your process of creating this story?
Yes.
And what, could you explain to us what that role was to be?
To help give me some ideas from the point of view of some men who might belong to this particular group, Men Against Women, and how men would be frustrated by some of the actions of some women, and what kinds of things they would do to possibly stonewall women or make it uncomfortable for them, how they might react where they partnered with women, how they reacted to the administration, how partners' relationships, procedural issues.
So you wanted him to recount for you his own personal experience?
Objection, that's legal.
Sustain.
Did you communicate to him in any way an expectation as to the nature of the information he was to convey to you?
The nature of the information that I wish that he would convey would be something that would help me develop a story wherein a very competent woman officer is transferred into a precinct of where there's high crime, and she is forced to work with an officer who is a member of this particular group, Men Against Women. That was the structure or the characters that I really wanted to work with, and so the information that I needed from him was what would a working relationship be like? What would some of the frustrations be having to work with a woman officer? What would be some of her frustrations? And then possibly what could be some situations that might occur in a precinct such as this. It was structured after the 77th precinct.
Now, was there any difference between the nature of the first interview and the subsequent interview of Officer Furman?
That's vague, Your Honor.
Overruled. Do you understand the question?
Could you repeat it, please?
Was there any difference in the nature of the first interview that you conducted with Officer Furman and then the later interviews as the project developed?
Yes. In the first interviews, I really needed to hear what he had to say without directing him specifically, and be able to hear his words, his dialogue, the kinds of issues that he felt comfortable expressing to me. And in the later transcripts reflect that many of the points that we talk about are related to the story. I give general categories, and he responds. And the later interviews, I believe some of them are transcribed in terms of categories. It's not question and answer. It's more of a specified topical interview. And it also, my transcriptions during some of the interviews, the later interviews, were reflecting my lack of time. I had just had one child and was having another child and was working a couple of jobs and writing, and those things. So I had less time, and I really just needed to have him answer certain questions. So there's a difference in the transcriptions.
So the later interviews were much more directed to specific areas as opposed to getting background information?
Objection, Counsel.
Overruled.
Counsel Lee.
Overruled.
Yes.
Now, how quickly after the interviews took place did you prepare the transcript?
Within a day or two, I transcribed them.
So your transcriptions were done right after the interviews had taken place while they were still fresh in your mind?
Yes.
Sustain, answer stricken.
Why did you do the transcription within a day or two after the interview?
I was very interested in the project, and again, I had more time initially. I could work later hours. I could work early in the morning. My time was more fluid. But I really wanted to be able to transcribe them and hear the dialogue. It's easier to transcribe something, especially when there's interruptions. It's easier to transcribe it when you're closer to the topic.
And after you prepared a transcription of the interview, did you deliver a copy of that transcription to Officer Furman?
I believe the first transcript I sent to him, along with some questions that I wanted to pursue in the following taped interview. At some point after most of our interviews during 1985, I gave him the collection of transcripts. I don't remember if I sent him each transcript. I remember the first one I did.
Okay, so you recall specifically that after the first interview, you sent him a copy of the transcript with a set of questions.
Right.
Overruled.
Was that in anticipation then of your second interview?
Yes, I had given him a series of questions to think about and see if he would like to answer those in preparation for our next interview.
And then at the conclusion or at a point where you had conducted a number of interviews, you gave him a bound set of the transcripts?
Yes.
Sustained. She didn't say anything about bound transcripts.
Okay, do you recall the form in which you gave him a set of transcripts?
I recall giving him at some point after our initial 85 interviews that collection of transcriptions.
And in what form
I had
did you
given
give
it
them to
to him in a 3-ring binder similar to the way that I had bound mine.
Your Honor, we have a 3-page document. A copy has been supplied to the people, headed Furman Questions Round 2. We would ask these 3 pages be
All right, 1364.
1364 for identification. May I approach?
You may.
Ms. McKinney, I'm handing you a 3-page document with numbered items from 1 through 31, and it's headed Furman. Could you look at that?
Yes.
You recognize that?
Yes.
What is that?
These are the questions that I sent to Officer Furman after our first interview so that he could perhaps refresh his mind on what we had discussed, and then he would know what kinds of issues I would like to discuss the next time we met.
So you are actually giving him questions in advance of the interview, so for what purpose?
Well, time was limited. He was a very busy man, and I wanted him to understand what issues I really needed to talk about.
And did this list of questions contain specific references to the transcript that accompanied them?
Not every question. A few of the questions have references to page numbers of my original transcript.
Well, for example, item 15 on your list of questions, does that refer to a specific page of the transcript that you're asking him to look at?
Yes, item 15.
Okay. Item 16, is that a question that you asked him in the follow-up interview?
Yes.
And that question was, how do you hire someone who is capable of shooting someone in the back, number 1? And number 2, on what grounds would you determine who is capable of figuring out who the bad guys are?
Yes, that's number
Now,
16.
was that question drawn from a specific reference in the transcript?
According to this and my notes, that was referring to page 25 of the first taped interview.
Are there other references in those questions to the transcript, either by quoting material in the transcript or referring to specific pages?
Yes, generally when there's parentheses around a word, that indicates that it's something that we possibly discussed. For instance, number 27, why is the chokehold considered brutality? That would be something that we had discussed.
Now, at any time in the course of your interviews, did Officer Furman ever indicate that there were any inaccuracies in the transcript?
No.
Now, at the same time that you were conducting these interviews with Officer Furman, were you meeting with other persons associated with the Los Angeles Police Department?
Yes, I was during that period. I met with approximately 15 to 20 other officers from Los Angeles Police Department, either through the Parker Center on ride-alongs or some of the PTs at the Los Angeles Police Academy, along with around 20 to 25 police cadets there at the Los Angeles Police Academy, women cadets.
And did you also tape record those meetings and interviews?
Many of them were tape recorded. Some of the meetings and discussions with the cadet women were when I was there with them when they were in training and running and wrestling, watching them do that and observing their pre-training prior to entering Los Angeles Police Academy. So many of those were very informal and they weren't taped, but several of them were.
Now, were all of the interviews you conducted with Officer Furman just yourself and Officer Furman, or did you ever involve any third persons in the process?
No, there are several interviews where there is another party involved.
And for what purpose was that done?
Sometimes it's to give me additional information that it's hard to be able to acquire when you're conducting the interview, because it's a one-on-one and you're looking at someone and trying to respond appropriately. You're not observing. So that was helpful information. One particular interview was a woman who was going to pretend to be a woman who wanted to enter the police academy, and Officer Furman was going to talk with her about his feelings about that. Another interview was with a gentleman with whom I was working at UCLA, an athlete who was going to talk with Officer Furman. Another was with a gentleman who had optioned the piece, and it was more of a partial story conference.
Now, did these interviews with the woman who was portraying someone interested in going into LAPD and with the gentleman who was a student of yours at UCLA, did you say?
Yes, he was one of the students with whom I worked.
Perhaps you could identify these individuals. Who were these persons who played these roles?
By name?
Yes.
You was like, the woman was Lori Diaz. She was a personal friend who agreed to do this confidentially. And the gentleman was James Washington. And the producer was John Flynn.
And were these interviews tape recorded as well?
Yes, they were.
And did the interviews with Lori Diaz and James Washington also take place in 1985?
Yes.
Did you find any of the comments that Officer Furman was making in the course of your interviews offensive?
Oh, well,
I heard your question. I didn't hear what happened with the court after that.
I
I'm
believe
sorry.
you
you can answer the question.
Okay. Yes.
Did you ever confront him or question him about the statements he was making?
Generally, no.
Why not?
I had a journalistic approach to this project with all the people that I interviewed. And for me, that means that when I'm trying to hear someone's point of view, even though I might not espouse their feelings, whether they're a man or a woman, I don't react in a way that will cause them to drop their feeling of confidentiality their desire to communicate their ideas with me, so I don't respond in a way that will cause them to stop talking to me.
Your Honor, at this point, we would like to take Ms. McKinney through each of the items in our offer of proof to have her authenticate the context of the conversation, that in the case of the transcriptions, it is an accurate record of what Officer Furman said, and where we do have a tape recording to authenticate his voice.
Proceed.
We do have a video that was prepared in advance, which would display the text, and where we have the voice, play the voice accompanying the text. With the court's permission, I'd like to utilize that in the examination.
Proceed. I take it have you given a copy of this to the prosecution?
Yes.
All right. Proceed.
Uh,
We'll mark the tape, the videotape, as Defense Exhibit 1365.
Perhaps it would help if Ms. McKinney were able to look at a copy of our offer of proof at the same time that we're displaying the text.
Perhaps it would save some time. I don't think that there's going to be any question about the authenticity of the tapes. The tapes speak for themselves. The only question is the transcripts where there are no tapes. And I think that having Ms. McKinney go through tapes which do speak for themselves is just going to spend a lot of time proving the obvious. We could probably save a lot of time by cutting to the chase and going to the transcripts where there are no tapes.
Well, there does have to be some foundation that she recognizes the voices and who's there, though. Some basic foundation.
I think one of the issues,
Stipulate that she would identify her voice and that of Mark Furman on tapes.
I think one of the issues Your Honor has to address is how much consumption of time will be involved in presenting this to the jury. I think we can very expeditiously kind of give you a preview of precisely how this material would be presented to the jury so that Your Honor is in a better position to rule.
All right, well, let's at least start with the non-transcribed matters.
There's the additional issue of whether she had an independent recollection apart from the tapes. And that would have to be established.
Well, I'm sure that'll be on cross-examination gone into.
Well, the problem is foundationally speaking, Your Honor, that the tape should not be played until that area is explored, because then you get into a leading situation.
No.
I intend to elicit, as we go through each excerpt, her memory of Detective Fleming speaking those words.
Proceed.
If I can approach.
Yes.
I'm handing you, Mr. Kinney, a copy of the offer of proof that was prepared for the court, containing excerpts from the transcripts and the tapes that were supplied pursuant to subpoena to the court.
All right, and which page are you referring to?
We'll begin on
offer
page 9.
The amended offer.
For the record.
It's the amended offer,
Yes,
not the initial.
yes, the amended offer of proof. All right, if we could begin with...
Wait. Did you change the numbers in the amended offer of proof?
No. I'll be referring to these excerpts in terms of the three categories we established, Your Honor. B being racial animosity and the use of racial epithets, which will include items B1 through B40, and actually we added one more, B41, in a supplement to the offer of proof. And then,
Let me ask you, just as out of sheer curiosity, do you actually anticipate that any court would allow you to have all 41 of these incidents? Isn't there some cumulative problem here? or redundancy?
Well, I certainly plan to address the question of the cumulative issue in the argument. If you'd like, I'll address it now.
Well, I'm just asking, you think in presenting this issue to the court, do you think I really need to contemplate all 41 of these? Aren't there perhaps a half dozen of these that capture the essence of what you want to present?
Well, we believe there are 17 to be exact that will be admissible for two purposes, not only to show the use of the word, but to show actual racial bias and hostility. And
All right,
certainly,
then why do I have to listen to 41? So you've conceded at this point that the remainder is.
well, certainly,
surplusage.
I think we're entitled to elicit that there were 41. But in terms of the ones that would actually be displayed or heard, it's not unreasonable to suggest that the actual display or hearing of the epithets would be limited to the ones that have relevance beyond simply the use of the word nigger. I'm certainly not going to argue that there's any evidentiary significance to hearing just that word 41 times, but we believe the context in which the word is used in many of these examples goes beyond simply the use of a racial epithet.
Then wouldn't it be a more efficient use of my time, your time, and the jury's time if you limit yourself to the 17 that you think are the ones that are appropriately offered to the court?
I think we're kind of jumping the gun at this point to start talking about editing it in terms of the offer of proof. What we would like to do, and we can go through it very quickly. I mean, these will not take much time at all, and we've edited them down to the bare bones so that in each case it's just the couple of sentences surrounding the use of the word, and Ms. McKinney can put it in context. And it won't take much time at all. And then at that point, the court will be in a position to say, well, now we need to talk about what the jury should actually hear.
You're offering me 41, but you really only want 17.
No, we want 41. I mean, I think that the counter argument obviously is going to be, well, you know, this was inadvertent. He didn't remember speaking these words 7 or 8 years ago in the context of a screenplay interview.
Play your tape.
Okay. Could we start with number 1, please?
I thought we were going to start with the transcript.
Number 1.
Number 1 is from transcript number 1. There's no sound.
All right, that was number 1.
That was number 1. Do you recall Officer Furman speaking these words?
Yes,
And when and where were they spoken?
and they were spoken on April 2nd in a first taped interview.
All right. And this is the interview that the tape was inadvertently taped over. Is that correct?
Yes,
And are these words that we've got females and dumb niggers and all your Mexicans that can't even write the name of the car they drive, is that an accurate record of Officer Furman's actual words?
yes,
And this transcription was made while those words were fresh in your memory.
Objection, that's leading.
Sustain.
That's
Stricken.
foundational, Your Honor.
It's leading, counsel, and it's the issue that's before the court, wouldn't you say?
Right? Did you prepare this transcription of these words immediately after you heard them?
It's awful.
Sustained.
How soon after you heard these words did you prepare this transcript?
I prepared this transcript within a day or two of the interview.
And as you look at these words now, are they an accurate reflection of what was on the tape?
Yes,
And they accurately record what Officer Furman said to you on April 2nd?
yes.
Oh,
All right, if we could have the second excerpt. Do you recall those words being spoken by Officer Furman?
Yes,
And when and where were they spoken?
they were spoken during the first taped interview in early April.
And again, that was recorded how soon after the words were spoken?
Within a day or two, that would have been recorded at the same time.
transcription.
That would have been transcribed at the same time the previous.
Now, in
Excerpt.
this excerpt, there is a blank. It says, if I'm wrestling with some blank nigger. Is the blank something that you put into the transcript?
Yes,
And why would you do that?
it would have been a word that was inaudible, but I just wouldn't type out inaudible. That would let me know that it was something that I didn't understand.
All right? So you would, if there were inaudible words that you could not record verbatim, you would indicate by inserting a blank into the transcript?
Yes,
If we could have the third excerpt, please. Do you recall those words being spoken by Officer Furman?
yes.
And when and where were they spoken?
During the first taped interview
On April 2nd?
on April 2nd.
And does the transcript accurately record what was said by Officer Furman at that time?
Yes,
And how soon after did you make the transcription of this comment?
within a day or two of the interview.
All right?
excuse me, Mr. Kinney, with
Sir.
regards to this April 2nd interview, you transcribed the entire tape within a day or two
Of the interview.
of the interview?
Yes. In one sitting, I transcribed the entire interview.
All right.
Number 4, please. Do you recognize those words as being spoken by Officer Furman?
Aside from Fatburger, yes.
You don't recall a specific reference to Fatburger?
I do reading it, but I don't have a recollection unless I read it.
Do you recall the context in which these words were spoken?
We were talking about the way some
Oh,
we
you
were
can answer the question.
we were talking about the way some suspects may be arrested, and I'm not familiar with 22nd and Western, so it didn't set up a visual picture for me. where Fatburger was.
At the time of these interviews, Officer Furman was a patrol officer in Westwood, is that correct?
Yes,
In this excerpt, was he describing an event that actually took place while he was working as a patrol officer in Westwood?
Objection, no foundation.
Sustained. Foundation.
Could you explain how it came about that he described this incident to you?
Objection, as
Well,
I need to see my original transcript to be able to read what comes before.
All right.
and I'll object to that procedure, Your Honor.
on what basis? Overruled.
Well, may I?
You may.
I have here, Ms. McKinney, a set of the transcripts that have been prepared, including
She indicated she had limited recollection.
She's indicated that she needs to refresh her recollection from her original transcript, is what she's indicated.
Does the binder I've just handed you contain your transcription of the first interview on April 2nd?
Yes,
If you could refer to page 33 of that interview. Does that page contain the Fatburger excerpt?
yes.
Putting that in context, can you tell us whether this was an explanation or a description of an actual event?
Objection, no foundation.
Overruled. You can answer the question.
Could you ask the question again, please? I was reading.
Is the excerpt a description of an actual event?
For conclusion.
Overruled.
This is a description of an actual event that took place, according to Officer Furman, on the previous night.
So he was telling you what had happened the night before. Is that
Yeah,
correct?
That's correct.
If we could have the next excerpt, please, number 5. Do you recall those words being spoken by Officer Furman?
Yes,
Can you put them in context for us? What were you speaking about at the time?
we were talking about the administration of LAPD, some of the other administration officers.
So the reference to Commander Hickman, is that a reference to an actual person?
Yes, it is.
And approximately when and where was this statement made?
This was made during the first taped interview on April 2nd.
And is the transcript an accurate record of what Officer Furman said at that time?
Yes,
And it was made how soon after the conversation took place?
within a day or two of the taped interview.
We could proceed to number 6. Do you recall those words being spoken by Officer Furman?
Yes,
And when and where were they spoken?
they were spoken during the first taped interview, April
Yeah.
2nd.
Why don't we just assume all of these are during the first interview until we get to,
Fine, Your Honor, I'll proceed on that assumption. What were you talking about at the time? In what context did this reference to Ethiopia come up?
I need to refer. It was a tangent. It wasn't specific to the story. But we had been talking about the media and the media's role in projecting a positive work capacity for women.
And this was an event or an event that was in the news at the time?
Sustained.
Was there some topical nature of this reference to Ethiopia?
I don't know.
If we could have the next excerpt. Do you recall those words being spoken by Officer Furman?
Yes,
And the transcript that we just presented is an accurate record of what he said?
yes.
What were we talking about, or what were you talking about at that time in the context of discussing people in some place don't want niggers in their town?
We were discussing where Officer Furman grew up in Washington.
The state of Washington?
Yes,
So here he was recounting his own experience of growing up, is that correct?
Objection.
Sustained.
Could you tell us whether what Officer Furman was describing was based on reality?
Objection.
Sustained.
In what context was this statement made in terms of whether it reflected actual events or whether it was fictional?
Overruled. Overruled. What context was this comment made in?
he was talking about where he grew up. I grew up in Washington. I mean,
And the record was reading the transcript.
Yes, actually, why don't you take that back, because she only asked to refresh her recollection as to that one item. The issue here is testing her recollection. That's one of the issues here, since there's no tape recording.
Well, do
Why
you
don't you just
recall?
close that and put it up on the...
Do you presently recall in the first conversation talking with Officer Furman about his personal background and where he grew up?
Reading.
Overruled.
I recall talking with him about this particular issue where he grew up.
We could have the next excerpt, please. You recall those words being spoken by Officer Furman?
Yes,
And is the transcript we just presented an accurate record of what Officer Furman said in that first interview on April 2nd?
yes.
And in what context were these words spoken?
We were discussing the difference between PT officers, physical training officers at the academy when Officer Furman trained as opposed to PT officers at the academy at that particular time in 1985.
All right? Do you have the next excerpt? Do you recall Officer Furman speaking those words?
Yes,
And were these spoken in the first interview on April 2nd?
yes,
Is the transcript an accurate reflection of what Officer Furman said?
yes.
And in what context was this statement made?
He was explaining the use of the chokehold and the reason for eliminating it.
Right? Your Honor, that concludes the excerpts from the transcript number 1, which was the first interview. We can now proceed to interviews where we do have audio tape available.
All right,
We could
proceed.
have the next excerpt, please.
Now, people have often stipulated the authenticity. And it takes speak for themselves.
Mr. Ullman?
Well, Your Honor, we need to make the same showing in terms of the context in which these words were spoken.
Your Honor, obviously, the court has the entire transcript to the extent that there is context available. The court already has it. And it takes speak for themselves. We have the entire tape for this. There's no need.
All right. Mr. Ullman, though, I think he does need to establish at least some basic foundation as to the voices. Proceed.
You know, policemen also use it bubba a lot, you know, because it's a slang term, because niggers, you know, they call each other bubba. Sometimes you go, hey bubba, you know, what's happening, you know, and stuff like that. So there's a lot of that kind of conversation, and somebody will say,
Do you recall those words being spoken by Officer Furman?
Yes,
And you recognize his voice?
yes,
This is an actual tape recording of an interview you conducted?
yes.
And when and where did this conversation take place?
This was in April.
So, Madam Mayor, what is the
She has the offer.
The
of proof.
offer of proof.
You objecting to that? All right, would you put that down, Ms. McKinney? Turn it over.
And when and where did this conversation take place?
This took place sometime in April
Of
of
1985.
1985.
Right? And do you recall the context in which those words were spoken?
Yes. We were talking about nicknames that officers or partners give to each other.
Thank you. Do we have the next?
Excuse me just a second. Ms. McKinney, in your transcript, you have down Baba, B-A-B-A. What I heard was Bubba. Do you distinguish between those two terms?
Is there a difference between those two terms? Yes.
All right. Which is accurate, your transcript or the transcript that we just saw here?
B-U-B-B-A.
Bubba?
Yes.
All right, so your transcript, original transcript is not accurate as to the specific term.
No, it's a misspelling.
Do we have the next excerpt?
People have often stipulated.
All right, Ms. McKinney, have you listened to all these other tapes? All the other tapes that you've given to the lawyers in this case?
I listened to them when I transcribed them, yes.
All right. Mr. Ullman?
Could we proceed?
No, if she's saying that these are all Mr. Furman on the tapes, I don't need to hear anymore. I've read the offer of proof, I've heard the tapes, I've read the transcripts.
There are issues that come up, Your Honor, in terms of the context of each of these statements. The people, for example, in their brief, have argued that some of these involved the fictional role-playing in which Detective Furman or Officer Furman at the time was entering into some sort of a fictional context at the time he spoke. Of course, our contention is that he still used the word, and when he testified, he didn't make an exception for fictional role-playing, so that's simply a question for the jury. but as a foundational matter, we believe that with just a couple of exceptions, we can show that each of these uses of the word were in the context of conversation in which he was recounting actual experiences or giving his personal opinions, and did not involve creating dialogue or role-playing with respect to fictional characters. So
All right.
we'd like to proceed to show the context of each of the statements.
Well, let me ask you this then. Then why was it necessary for me to take all these tapes home with the offer of proof, with the transcripts, and read all this stuff and listen to all this stuff?
Well, so Your Honor could put this all into context. I mean,
Okay.
we are dealing with a very
I've heard it.
selective
I've read it.
editing.
I've seen it. All right?
Could I have a moment? We're in a position, Your Honor, where not knowing how Your Honor is going to rule on any of these offers, we believe we're entitled to make a record to show the admissibility
record.
and the
You
and the
have a written
relevance.
offer of proof. You have these tape recordings. You've lodged the transcripts with the court. You have a record. What more do we need to do?
Well, I think Your Honor needs to have a sense of how this is going to be presented to the jury as well. I mean, our position is what we have done with a massive amount of material is to refine it, to edit it, to put it into a format where it can be very concisely and with great precision presented to the jury, just cut to the bare bones of what is relevant without any embellishment. And I think that's a very relevant factor for Your Honor to recognize in terms of considering what you're going to admit and allow the jury to hear. And I think it would be very helpful to Your Honor to see just how and in what format and in what context we intend to present this material to the jury.
But this video was submitted to the court yesterday afternoon, correct?
Yes,
All right. As part of the offer of proof.
that's correct.
All right. So I've seen it.
But Your Honor has not heard any testimony as to the context in which each of these statements were made.
But don't I have the transcript for that purpose?
Well, the transcript, they're saying, they're objecting to her even looking at the transcript in terms of her own memory of the context in which these statements were made and the conversations took place. We believe we have a right to present the testimony of the witness who will actually testify before the jury to establish the context of each of these statements, to show that in fact these are the opinions, these are the personal experiences of Officer Mark Furman. These are not fiction, these are not the creations of a playwright. These are the words that he was speaking in terms of his own life experience.
All right. Proceed. Her comments on the context.
All right, I will limit.
Understanding. I've read it. I've listened to it.
I'll limit my questions as we go through each excerpt to simply having her put them in context.
All right.
Witnesses' memory, as dim as it may be 10 years later, for context, when you have the entire tape conversation for context.
Well, we don't have the entire tape conversation. There are a lot of stops and starts here. It starts in the middle of conversations. It ends in the middle of conversations. I don't know what the predicate was to all of these things. There are a lot of unanswered questions with these tapes.
And we're assuming that this witness can now remember this?
That's a judgment call, isn't it? Proceed.
We have
Thank
the
you.
next excerpt.
I think we're on. Hold on. We're on number 12, correct?
Yes,
Okay.
number 12.
And it's going to be necessary to play all of the tapes to give her testimony to the context, as opposed to letting her look at the transcript, she's got the file in front of
No,
her.
the tape and the spoken word is the best evidence at this point. All right, Mr. Harris, just rewind that shortly, please.
Number 12?
I want you to search them. There. Stop.
Yes.
See who they are.
You haven't talked about it in that
Yeah, any problem calls. You got it.
Okay.
Just, you want to know who they are?
Can you tell us the context in which those words were spoken?
Yes, this is related to the story. I would be helpful to look at the transcript, but to my best recollection, I was asking how an officer would approach a suspect and stop a suspect. And these two suspects, or the suspect, I believe they are black Muslims.
All right, we have the next exit.
Black Muslims would go a long ways.
Why do they live in that area?
And do you recall the context in which those words were spoken?
It's a similar context as the last.
Was this immediately after the previous excerpt about stopping?
I don't know. I would have to see the transcript.
Would it help if you looked at the transcript in terms of?
Yes, because there are two times where a suspect is stopped, one in a car, and I asked for that information, how an officer would stop what they consider to be a suspicious car, what kind of issues would come up in that, and then there's another time where an officer is stopping two suspects on a street. So there are two different times.
All right. Would it refresh your memory to look at the transcript?
Yes.
Could you look at the transcript for tape number 1 at page 28?
Go ahead.
Does that refresh your memory?
Yes.
And in what context were those words spoken?
This would be the context regarding the black Muslims stopping two suspects on the street who are black Muslims.
In terms of where that would be likely to take place?
Yes.
We could have number 14, please.
On top of a bunch of bodies going. I mean, that's just the way you feel. You know, you got 200 niggers that are trying to take you to prison, you just chase this guy and beat the shit out of him.
Do you recall the context in which those words were spoken?
I remember it being said. I don't remember the context.
Would it refresh your memory to look at the transcript?
Yes.
All right, could you look at transcript number 2 on or transcript of tape number 1, page 1. Does that refresh your memory?
Yes.
And
Officer,
in what context were those words spoken?
Officer Furman is explaining what it feels like to work on this particular mid-watch.
All right. Could we have number 15, please?
She is a female. She's a policeman in the city. And don't you ever fight or fuck around with a policeman. You do what you're told. You understand, nigga?
Do you recall the context in which those words were spoken?
Yes.
And what was that?
My best recollection is it was a situation where I was asking how an officer would respond to transporting a suspect who had beaten up or hit a woman officer.
All right. Number 16.
I'm going to invoke an objection again. I do not, well, I don't know, let me inquire of the court. Is this at all helpful to the court in giving it any additional information over and above what it already has in the defense proffers?
No, this is the person who's conducting the conversations and interviews of Detective Furman. She has unique personal knowledge as to each one of these individual situations.
What unique personal knowledge has she imparted thus far that we haven't already gotten more of in the proffers themselves and the actual transcript?
Well, at some point in time, I'm going to ask that question, but I'm letting Mr. Ullman go with what he feels is appropriate at this point.
There are a number of excerpts we'll get to in a moment where there were others present, and an additional set of excerpts where we do not have a tape, Your Honor. So I think this will be very helpful. Could we have the next excerpt?
Nigger with a knife. Go on guard.
Recall those words?
They were, I need to
I
see
think
them
we-
again. They were,
All right. Could we repeat that?
I heard it.
Just go out there. What are you going to do with some nigger with a knife? Go on guard? That's bullshit.
Do you recall the context in which those words were spoken?
I believe, yes, we were discussing fencing. It would be helpful to look at the transcript, but to my best recollection, we were discussing what it would be like to be fencing to officers, and Officer Furman was saying that something to the effect that even knowing fencing isn't particularly useful because that's not something that an officer would be called upon to use in a line of duty.
So when you refer to fencing, you're referring to sword fights,
Yes.
right? Could we have the next
All right,
excerpt?
hold on. Madam Reporter, all right, we need to take a recess. All right, we're going to take a 15-minute recess at this time, and Ms. McKinney, you may step down, come back in 15 minutes, all right? Thank you. Epithets that the defense is seeking to offer before the jury, and I'll have Mrs. Robertson file this as an addenda to the defense offer of proof.
Your Honor,
Excuse
what
me,
this
counsel.
list-
Excuse me.
Yes. I'm sorry.
All right, we'll addend this to the amended offer of proof. Previously, the court had ordered the offers of proof and the response sealed. because of the inflammatory nature of the content. And I have decided that given the fact that we are now publicly discussing the content, that I'm going to unseal the proffer and the prosecution response, and I'll instruct my staff to make that available over the noon hour. Secondly, Mr. Ullman, over the recess, I had the opportunity to sit and contemplate for a few moments. And I agree with the prosecution that the court does have, I think, ample context, having read the entire transcript with regards to each of the identified excerpts that you wish to play. However, I think that there is a overriding public interest in the nature of the offer that you're making. And I don't want this court to ever be in a position where there is any indication that this court would participate in suppressing information that is of vital public interest. I think that's already been expressed by the city attorney's office, and it's been expressed by other interested entities that this information be made public. So what I'm going to suggest we do at this point, Mr. Ullman, is that you play your video presentation to the court in its entirety without further interruption. I'll hear it again, and that'll be for the purpose of public dissemination of this information. But I have read and considered and listened to all of this.
All right. Your Honor, if we could just make one request. There are some excerpts where, for example, it refers to Officer Furman nodding without describing the nature of the nod. It refers to a ripping motion in the course of the discussion of what you would do with a driver's license, which does not appear in the transcript. We would, with respect to those excerpts, request to stop the tape and just put a few questions to...
Well, let me ask you about number 15. Miss Detective Furman is heard to make some noises at the end of the tape, which in my, I guess, screenwriter's imagination thought he was discussing, this is where the context was, how would a police officer respond to transporting a suspect who's been arrested for assaulting a police officer? And Furman says, well, you would tell them you don't do that to anybody, any police officer, be they male or female. And then he makes some noises, which, given the context of the other tapes, I interpreted as either baton shots or something like that, gestures similar to that, which are not recorded. So if that's the context of the gestures that are being made, I don't know. So I agree with you, there may be some portions where you need to stop. But other than that, I think I understand the context.
All right.
Are we clear?
Well, could we back up then to 17? Yes. We have a problem with our court reporter.
No, we don't have a problem.
We don't
with
have
our
a
court
problem.
reporter.
We have a problem with us. The transcript simply reflects silence while the displayed portion of the excerpt is displayed, and then questions about that excerpt. If we could have a stipulation that at that point we could insert into the record the actual words of that were being displayed at the time.
Well, we are referring to by excerpt keyed to the offer of proof. The offer of proof also has the text, so the text is there. The record, I think, is adequate.
All right. And I also wanted to clarify that the list I gave, Your Honor, of the 17 instances are instances that we contend are relevant both to show use of the word and to show racial bias, but
I
that's
understood-
not
I understood that
necessarily a
the first time.
withdrawal of all 41 uses of the word.
All right, let's start with 17. Let's resume with 17.
We have just Your Honor, the present format that we have on the tape is a 20-second delay between each excerpt.
That will give you the opportunity to say, this is excerpt 17.
All right, and we intend to shorten that for actual presentation to the jury so that we don't have 20-second delays between each excerpt. Are we ready to proceed? This is excerpt B17.
We have audio.
We should.
Let's go over to practice movements. Niggers. So easy. I always practice my kicks.
Now excerpt B18.
That's a good point.
Physically capable? Wrestle 6'7" niggers.
That's a really good point. We'll have to bring that in.
Excerpts 19 and 20, what we've done is number each use of the word. So this is one excerpt with two uses of the word.
You know why we stopped the show?
Tell me, please.
We stopped the show because a bunch of niggers have a bunch of these organizations in the South End, and because all niggers are choked out and killed 12 in 10 years. Really extraordinary, isn't it? 10?
Next we have excerpts 21 through 24, four uses of the word.
Think of that. 3 plus 1. I came on this down here. 3 plus 1. You
Hold on, Mr. Harris. Is that one of the enhanced versions?
That's it, it is.
Okay.
To reduce the background noise.
Thank you. All right, 25.
Number 25.
So he grew up in the street. He grew up in school. All life. Every time I take a look at him, he just jumped on it. He figured he'd just jump on the other side. I'll start to ride right now and get it over with.
I believe that too is an enhanced tape, Your Honor. Number 26. Proceeding to 27, Your Honor, the record should reflect that this is the interview in which Lori Diaz is present, and these comments are also directed to her.
Officers out here, they don't do anything. They don't go out and initiate a contact from 6 foot 5. They just been in prison for 7 years, pumping ways.
And number 28 is likewise in the presence of Ms. Diaz.
How many people you killed there?
Give me the opportunity.
I didn't ask you that.
I haven't.
don't even know what
You
it's
haven't
like.
given me the opportunity yet.
You're talking shit. You're talking shit. You sound like a nigger. You're talking shit. You know, and until you've done something, you can't talk about it.
Number 29.
They had a bunch of midgets up there. 2 guys, they're like 5'6". They got punched right in the face. I mean,
Number 30.
They're still going to use it.
there's going to be a massive in the future. We know that. There's rolling 60s. They went to a sporting store, stole 50 bullets, 3,000 rounds.
Number 31.
You don't need that. It just slows you down. They're like rabbits. You know, you better just concentrate their time. Some policemen just sit there and they just look. You have to tell them what to do. What's that?
You had a comment about that one?
Could roll that back. I believe my name was listed incorrectly on that,
All right.
just as an addendum.
the tape,
This is number 31.
number 31.
Mr.
Could you re-roll
Mr.
that?
Harris, would you run that back for us, please?
Thank you.
You have to tell them what to do.
Yes.
At the beginning, the record should reflect the speaker is identified as McKinney incorrectly. Is that,
That's correct.
is that Officer Furman speaking?
Yes, it is.
Thank you.
Some policemen just sit there and they just look. You have to tell them what to do. What's that?
Number 32.
Female responding to a call. What if I just been raped by $2? Some female shows up. What's she gonna do?
Your Honor, numbers 33 through 37, we do not have audio. These are all taken from tape number 9, which was inadvertently taped over. This is number 33. Should I put the words on the record, Your Honor?
No, they're in the offer of proof, as I recollect, aren't they, counsel?
Yes.
All right, so as long as you refer in the record to which offer this is, which is, we're on 33 now, correct?
Yes.
All right.
I take it it's unnecessary to elicit from Ms. McKinney her recollection of each of these.
I think since there's no tape, I think you do need to establish some foundation regarding when the transcript was done, accuracy, et cetera, et cetera.
All right. Referring to what was just displayed as excerpt number 33, Ms. McKinney, do you recall those words being spoken by Officer Furman?
I need to read it again or look at the proffer, please.
I'm sorry?
I need to read it again or look at the proffer, please.
All right. Can you look at the offer of proof, number 33?
I would ask that the witness look at the monitor, proper context. I would say.
That's true.
All right.
Right.
Could we display 33 again, please? Do you recall that statement?
I don't have an independent recollection of that statement, no.
All right. Now, if you could refer to your transcript number 9 at page 1. I believe it's in the front of the collection of transcripts that you have there.
Objection, Your Honor.
Oral. Oral.
Please. Referring to your transcript number 9 at page 1, do you have that?
Yes, I do.
Now, do those words appear in the transcript? Now it's funny because guys in internal affairs.
That's correct. As soon as she finishes reading.
Does that refresh your recollection?
Yes.
Do you recall these words being spoken by Officer Furman?
In the context of this, yes.
And in what context was that?
We were talking about a particular investigation, autopsy investigation of IA, Internal Affairs, related to an incident in the story.
And when and where did this conversation take place?
It took place in 1987,
Do you recall
approximately the summer of 87.
the date in 1987?
I don't recall the exact date. It would have probably been in the summer or spring or early summer.
Did you indicate a date on the transcript itself?
May I refer back to the transcript? I believe I
If
did.
that would refresh your recollection.
Oral. Go ahead.
The date on the transcript is
No, just read it to see if that refreshes your recollection as to
Oh.
when it was.
Does that-
I only recall that it was sometime in 87 in the spring or early summer. So yes, that refreshes
In
my
the spring
recollection.
or early summer of
Yes.
1987? And was that also in Los Angeles?
Yes,
And that would be true with respect to offers 34, 35, 36, and 37, Your Honor, that come from the same transcript. Do you actually recall word for word the words that Officer Furman spoke on that occasion?
no,
Is the transcript an accurate record of what Officer Furman said at that time?
the transcript would be an accurate record of what Officer Furman said.
And did you make that transcript soon after the conversation took place?
Yes,
How soon?
within a day or two.
And you didn't change or in any way alter the words that you heard on the tape in preparing the transcript?
Sustained. Rephrase the question.
Did you put into the transcript the words that you actually heard Officer Furman speaking on the tape?
Yes, I transcribed the words I actually heard Officer Furman speak.
All right, thank you. Could we proceed to excerpt 34? Do you recall Officer Furman speaking those words?
Yes,
And was that also in the spring or early summer of 1987,
yes,
in the same conversation as the previous excerpt?
yes,
And does the transcript accurately reflect the words that Officer Furman spoke?
yes.
Foundation.
We could proceed to number 35. You recall those words being spoken by Officer Furman?
Yes,
When and where were they spoken?
that would be in the same interview in 1987.
And does the transcript accurately reflect the words that Officer Furman spoke on that occasion?
Yes,
Number 36. Do you recall those words being spoken by Officer Furman?
no, I have no independent recollection of those words.
All right. Could you look at transcript number 9 at page 11?
Foundation.
Just read it to yourself and see if that refreshes your recollection as to what was there.
I'm sorry, I haven't found it on page 9.
No, page 11.
Oh, I'm sorry. Yes,
Refreshes your recollection?
yes.
Do you recall the context in which these words were spoken?
In terms of accountability for police officer actions,
And these words were spoken in the course of the same interview in the spring or early summer of 1987?
yes,
And the transcript accurately records what Officer Furman said?
yes.
All right, number 37. Do you recall those words being spoken by Officer Furman?
No, I have no independent recollection of those words.
All right, could you look at the transcript for number 9 at page 12?
Foundation.
Oh.
Yes,
That refresh your recollection?
yes.
Do you recall the context in which those words were spoken?
We were talking about the problems between different racial groups in LAPD, specifically Hispanics, Mexicans, and blacks.
And these words were spoken in the course of the same conversation in the spring or early summer of 1987?
Yes,
And does that transcript accurately record the words of Officer Furman?
yes,
Now, the next three excerpts, 38 and 39 and 40, well, specifically 38 and 40, make some reference to the 77th precinct. Did that have some particular relevance in the context of your conversations with Officer Furman?
yes.
Just so the record's straight, we don't have precincts in Los Angeles.
Division. Division?
Yep.
Could you explain what the 77th Division, what significance that had?
I had ridden along with some officers in the 77th, and I was modeling this particular division after the 77th.
For the screenplay?
For the screenplay, yes.
And where is the 77th located?
I forget the exact street location. I'm sorry.
Is that in South Central Los Angeles?
Yes. I just forget the exact location.
All right. Could we have excerpt number 38, please?
Well, why don't you give us 77 lie detector tests? You know, and just everybody, a bunch of guys will laugh old timers, and then like they'll ask us part of it, so keep choking out until they tell you the truth. You know, it's kind of fun with this. Wow, this movie. Anyway, so you're in the shadows like that. Now when you're talking to somebody, it's not like you're really listening to their words, because you'll key on what's the truth and what isn't. First thing, anything out of a nigger's mouth for the first 5 or 6 sentences is a fucking lie. That's just right out. There's got to be a reason why he's going to tell you the truth. He's just not going to go,
Excerpt number 39.
basically got impatient with him being so fucking stupid, which I thought he was. So, just handcuffed him and seen he crossed the station. Searched him again, found the gun. Went over to the baseball diamond and talked to him. And when I left, Dana goes, "No blood mark." No problem. Not even any marks in it. Just body shot. You ever try to find a bruise on a nigger? Pretty tough, huh?
Number 40.
Some gang set.
Oh, yeah.
Leave that old station, man. It's got the smell of niggers that have been beaten and killed in there for years.
They're big on this junction.
Do you recall the context of that excerpt, Ms. McKinney?
It would be
Discussion
helpful
about the new
to see
building
it.
for 77s.
You
It would
recall
be
that?
helpful to see it. It would only be in discussing the 77th and perhaps after a ride along that I had done.
Offer number 41, Your Honor, is not on the tape yet. It was added in our supplement to the defense amended offer of proof after it was located on a transcript of tape number 10. So if I could read it into the record.
It's actually at page 2 of your supplement, correct?
Yes. Quote, came up with a new name for niggers, anthrocide, ANTHROCIDE, dark gray color on Porsches. Now nobody's going to mind being called a anthracide, do you think? Do you recall Officer Furman speaking those words?
Yes?
And do you recall when and where that comment was made?
No?
Is that a misspelling?
It was just done phonetically, Your Honor, so it may well be. If you could refer to the transcript of tape number 10 on page 16, please.
All right. What's the purpose of this at this point?
Of 41?
Yes.
Well, it's the most recent of all of the offers,
All right. What's the date on this?
1988.
All right.
It's clear important that you take from this.
Yes.
I know all the take it all.
Yes.
Refresh your recollection?
I'm unable to find it.
Um,
It's not very coherently put together.
I think we may have the wrong transcript.
I'm looking
Because-
at tape number 10, page 16.
I think we're looking
I
at transcript.
understand the problem. What you have there is the transcript of tape number 10. But what we want to refer to is your transcript
Number 10.
number 10.
Why don't you show it to her, Council? Do you have it in the book?
Of that transcript, page 16.
Thank you.
This is the half-page transcript.
Yes, I remember it from my transcript, not,
All right, I'm sorry, Council, which
you can take that back.
page?
Page number 16 of the McKinney transcript, number 10.
Got it. Thank you.
Does that refresh your recollection?
Yes,
That appears under the name Farrell. Is that correct?
yes, it does.
Does that have some association for you in terms of how this occurred? Or-
I believe there was an Officer Farrell with whom Officer Furman had worked at one time, and this is a portion of the tape in which there were categories, and then transcribed.
And
The transcriptions are Officer Furman's words, but the categories are regarding my questions or the areas of conversation.
and is the transcription an accurate record of words that were spoken by Officer Furman?
Yes,
And do you recall approximately when this conversation took place?
to my best recollection, I believe it was 1988. This particular example doesn't help me know that. There's something else on that tape that helps me know that it was 1988.
All right, so in looking at that transcript, there were other portions that reminded you of the time that the conversation took place?
Yes,
What was that?
there's one reference to being a good father, or on being a father, and at the time I was either pregnant with my second child, my second son, or had just given birth. So I remember that reference particularly sticking. And then I think there's another reference to 1988 being the year of the gangs, and the next year being something else. I don't recall it verbatim.
So that, in context, was a conversation that you recall taking place in 1988.
Yes, I also remember this particular item because I didn't get it.
You didn't get it?
I didn't understand. It was a joke that I didn't
Now,
get.
this was a conversation that was taped over, is that correct? That where the tape was reused?
I don't know.
You haven't been able to locate the actual tape of this conversation.
That's correct.
But the transcript that you prepared, was that done shortly after the conversation took place?
Yes,
And is that an accurate record of what Officer Furman said?
yes.
We can now move on, Your Honor, to the C category, the police misconduct excerpts. And the first eight of these, the first 8 of these are all drawn from the first transcribed
second.
conversation. So if we could roll number 1 and then And we could proceed directly to number 2. Now, this excerpt indicates in parenthetical, in response to a question, have you done that before? Nods. Do you recall these words being spoken by Officer Furman?
Yes,
And did you indicate in your transcription the reference to nods?
yes,
And could you explain what you meant by that?
that Officer Furman nodded in the affirmative.
All right. So he was nodding his head up and down
Yes,
in an affirmative way,
yes,
as though he were saying, yes, I have done that before.
correct.
Thank you. Excerpt number 3. Excerpt number 4. We could just stop that for a moment. Referring back to the list of questions that you gave to Detective Furman after this interview took place,
Yes,
do you still have that in front of you?
yes,
If you could look at question number 16 of the follow-up questions you had posed for round 2 of your interviews.
yes,
Question number 16 is, how do you hire someone who is capable of shooting someone in the back, number 1? And number 2, on what grounds would you determine who is capable of figuring out who the bad guys are? Refer to page 25 of the transcript. Were you referring, Detective Furman, specifically to this excerpt in posing that question?
yes.
Thank you. If we could proceed to excerpt number 5. for a moment, and once again, Ms. McKinney, refer to the list of follow-up questions. Number 24.
Yes,
In follow-up question number 24, you referred Officer Furman specifically to page 30 of the transcript
yes,
and posed a question about meeting the guy who killed 2 police officers. Is that correct?
yes,
Is that a reference to the information in this excerpt?
yes,
Thank you.
Do you have any idea who this person was?
no,
Do you have any belief that this was a real person to whom Detective Furman was referring to?
I don't know.
Given your connection with UCLA, were you aware of any student who met that description?
No, I was not aware of that.
Number 7. Do you recall the context of excerpt number 7?
Yes,
Was Officer Furman describing an actual arrest in which he participated?
Objection. Also,
Foundation. Rephrase the question.
The excerpt starts out, so under what did you arrest him? Were you asking Officer Furman about an arrest of a specific individual?
I believe I was. I would have to see my transcript to be able to give an accurate assessment. But yes,
Could you look at transcript number 1, pages 33 to 34?
Foundation.
Or will
yes,
Does that refresh your recollection?
yes,
And was he describing an event in which he had participated?
yes,
sustain.
Could you describe the context in which he described this arrest?
he was discussing a suspect that he had arrested.
Do you know when or where this arrest had taken place?
Overruled.
The previous evening.
Thank you. Number 8, please. We're ready to proceed to number 9, which does have audio, Your Honor.
Proceed.
That's our number 9, please.
But that gives a lot of credibility when you got a real heavy investigation. But we had one, I had 66 allegations of brutality, PDW under color of authority, assault battery under color of authority, torture, all kinds of stuff. 2 guys, well, there was 4 guys. 2 of my buddies were shot in ambush. Police were both alive on this first unit of the scene. 4 suspects ran into a second-story apartment projects apartment. We kicked the door down, grabbed the girl who lived there, one of their girlfriends, grabbed her by the hair, second gun, we had to use her as the barricade, walk up and told us, I got this girl on board, fucking brains out, going on the gun. Yell her like this, threw the bitch down the stairs, did bolt the door. Let's play, boys.
When is that?
Huh?
Is that?
It hasn't been 7 years. Statute of limitations. A 300 and some page internal affairs investigation. Just on that one incident. I got several other ones. Must have about 3,000 or 4,000 pages of internal affairs investigation done there. Anyway, we basically tortured them. There's 4 policemen, 4 guys. We broke numerous bones in each one of them. Their faces were just mush. They had pictures through the walls or blood all the way to the ceiling with finger marks like they were trying to crawl out of the room. They showed pictures of the room. It was unbelievable. There was blood everywhere. All the walls, all the furniture, all the floor. It was just everywhere. These guys, they had to shave so much hair off. One guy just shaved it all off. He had like 70 stitches in his head. Knees, crack. Oh, it was just, we had to beg him to don't let it be gangbangers again. Begging us. So there's 66 allegations. I had a demonstration out in front of Hollaback Station, chanting my name. Captain had to take them all into roll call, and that's where the internal affairs investigation started. Lasted 18 months. I was on a photo lineup, suspect lineup. I was picked out. 12 people. That was pretty fun. I was the last one interviewed. Prime suspect's always the last one interviewed. They didn't get any of our unit, 38 guys, they didn't get one day. I didn't get one day. A custodian, the jailer at the sheriff's department, got 5 days because he beat one of the guys that they were ambushed at those suckers. Why? They all sucked. Immediately after we beat those guys, we went downstairs. The guard post in the back of the place, washed our hands. We had blood all over our legs. Everything was dark blue uniform, and in the dark, you can't see what you get in white. It looks like somebody red paint on all over. We had to clean our badges off with blood all over. Our face had blood on it. We had to clean all that. We checked each other. We went out, we were directing traffic, and the little chiefs and everything come down to 2 officers were shot. Where are the suspects? I think some of these officers over here got them and they took them to the station. So now nobody knows really who arrested them. We handcuffed them, threw them down 2 flights of stairs, got them first. And that's how they came down. That's where a lot of the people saw. Look out, here comes one.
How did you know what I
Oh my God, look out, he's falling. I mean, you don't shoot a policeman. I mean, that's all there is to it. But anyway, the point is, well, they know I did it. They know damn well I did it. There's nothing they can do about it, because most of those guys were 77 together. We came into this gang unit really tight. I mean, we could have murdered people. Got away with it. We're tight. We all knew what to say. We didn't have to call each other at home and say, okay, we all knew what to say.
Yeah. I mean, the point is, it's not that you want to murder people, it's just
Sure we
you have to
do.
kill people.
We'd love to.
Not everybody, just run around and be murdering people, just murder people.
Most real good policemen understand that. They would just love to take certain people and just take them in the alley, blow their brains out.
Certain people. People think, you think.
All gang members for one.
All gang members, yeah, well,
All dope dealers for 2.
Sure.
Those are two exam pimps. Right. They're probably your three most worthless type of people in Water City. But that's here and there.
Do you have a particularly vivid memory of that account?
Of course.
Why is that?
It's it's vividly described.
Do you remember any discomfort in hearing it for the first time?
Relevant, sure.
Or
Yes, it's one of the. It was very uncomfortable to sit through that. But as I mentioned before, I was in a journalistic mode, trying to get that type of information.
Thank you. Shall we proceed?
now let's take a break. All right, ladies and gentlemen, we're going to take our recess for the morning session. Ms. McKinney, I'm going to direct you to come back at 1 o'clock. All right, we'll stand in recess till 1 o'clock.
Please clear the courtroom.
All parties are again present. Ms. McKinney is on the witness stand undergoing direct examination by Mr. Ullman.
Thank you.
All right, we had just completed, let's see, this was C9.
Yes.
All right, proceed.
So we're up to number 10. Good afternoon, Ms. McKinney.
Good afternoon.
If I could just clarify a couple of questions that came up this morning. You indicated that on one of the interviews, you asked Lori Diaz to participate.
Yes.
And what instructions did you give her with respect to her participation in that interview?
We asked that question already.
I'm not sure it was clarified that she was actually role-playing.
She was playing as a woman who was thinking about going on the police department, correct?
Yes, that's the only point I wanted to clarify. She
It's clear.
actually didn't want to be a police officer, is that correct?
No.
She was just playing that role?
Yes.
Was Detective Furman told that she was playing a role, or was he told that she wanted to be a police officer?
Initially, he was told that she was a friend of mine who was considering going to the police academy and entering this CPA program and to be a police officer.
Thank you. And you also indicated this morning that as the interviews progressed and you had less time available, the nature of the editing that you conducted was different with respect to the later transcripts than with respect to the first one.
Yes.
Could you describe what you mean by that in terms of how the editing process differed?
Initially, I was more exact in giving the questions and the answers. Later, I sometimes omitted my question because I knew what it was and I didn't need to transcribe my question.
Right, so you did not use a question-answer format for the later transcriptions, is that correct?
It was more random. Sometimes, again, it was based on how much time I had to transcribe in consideration of family life, work, and other projects in which I was involved.
Did your editing ever involve changing anything that Officer Furman said to you?
No.
So even in the later transcripts where you were editing out your questions, you were still putting verbatim the words that Officer Furman used into the transcript?
The best that I could hear on the tape, yes.
Thank you. I believe we can proceed then with excerpt number 10.
No. I really love being a policeman. When I could be a policeman. It's like my partner now. He's so hung up with the rules and stuff. I get pissed sometimes. I go, you just don't even fucking understand. This job is not rules. This is a field. Fuck the rules, we'll make them up later.
Well, I don't get it. I mean, that's so critical.
The college graduate goes to college, Catholic college, he's gonna be a fucking priest. He's got more morals than he's got hair on his head. He doesn't know what to do about it.
I think it's something more.
He doesn't know how to be a policeman. Like, I can't lie. Oh, you make me fucking sick, man. You know, you do what you have to do to put these fucking assholes in jail. If you don't, fucking get out of the fucking game. And he just wants to be one of the boys, but he doesn't want to fight, you know, pay the dues.
So how to do it?
He doesn't want.
Not others, partners. So do something that.
Oh, I know for a fact there's some Trump affairs investigation. He's going to take 10-day suspension. I know that.
I'm sorry.
So drop it down. Square up. Tell the truth. Because it won't take any time.
You serious?
Mm-hmm. Policeman. He's considered one of the good guys.
You want 10 suspension at all?
Let's say. He said to me once, he goes, I got a wife and kids to think of. I said, fuck you. Don't tell me because you've got a wife and a kid. You're either my partner all the way or get the fuck out of this car. We die for each other, we live for each other. That's the way it is in the car. You lie for me, up to 6 months suspension. Don't ever get fired for me. Don't get indicted for me. But you'll take 6 months for me because I'll take it for you if you don't get the fuck out of here. It shouldn't have to be said.
Excerpt number C11.
Counsel, I'm a little concerned about the breaks in the tape, the fade in and out, and obviously a start-stop there. Do you want to ask some questions about that?
I can inquire about that. Was there any interruption in the taping that you can recall of this incident?
No, I can't recall any purposeful interruption of this incident.
Was there any occasion when the tape recorder was moved in the course of tape recording?
In this particular incident, again, I don't recall. There were times when the batteries would run down and I'd have to stop and replace the batteries. There were times when I had to, it would stop, the indicator would pop up and I'd have to restart it again.
As you heard this particular excerpt, was anything left out of what was actually said by Officer Furman?
Objection.
Oh, well,
Not to my knowledge, but it's possible, but not to my knowledge.
If we could proceed then with excerpt number 11. Just one further clarifying question. The excerpt you heard, did it capture the essence of what Officer Furman was saying?
Objection.
oh, well. You can answer the question.
Yes, We were discussing partner relationships.
Thank you. Number 11.
I'm still not understand who promulgated the
There's a black coalition against police in the South End. There's a ACLU, the NAACP, and
The ACLU.
Uh-huh.
My editor on something like that. There's an article on that it's written.
ACLU should be bombed, and everybody should be killed in it. They do no good. Society.
You know.
Now, in this excerpt, there is a question asked by you with reference to an article that you have that does not appear in the transcript. Is this an example of the kind of editing you were talking about?
Yes, that would be an example of something that I might have edited. I don't have any of my other research material with me, but there had been some articles in the Los Angeles Times that I was referring to in this particular portion. And I believe I had the article there with me.
Excerpt number 12.
He's the kind of guy, you get some jerk off, like some Mexican, like a skateboard, some game. He's cold skateboard addict. He's dog. Can't really wrestle for anything. Well, I'm talking to this kid, putting a skateboard underneath the tire of the black car. Okay, let's go. What was that? Don't worry about it.
There's a point in that excerpt where he makes a noise, okay, let's go. Did you hear that?
Yes.
Could you describe what was going on at that point?
It was he was making the sound that the skateboard would make when it was ran over by the tire of the car.
So he was imitating kind of a bumping sound?
Yes.
Thank you. Number 13.
Constantly turn on driver's license. Yeah.
You do that, I probably got that from you.
So he has his own style. So, well, your driver's license. Yeah, yeah. It's not the driver's license. That car.
If somebody arrests the kid with the driver's license, what can that person do? They can just go on.
Oh, yeah.
That?
Stole from. Oh, it's not the person's property. It's property to Department of Motor Vehicles.
But in this design, right? That's really your word against theirs?
Well, I can't be witnesses. He's a neighbor. You got other officers in the room. You're kind of part of the group, but they only want to go so far. And they're always not kissing up the supervisor, but they can't tell there's no problem. Real help to make it sick to your stomach almost. There's still decent guys you can count on, but there's that.
They're real helpful.
They want to be part of the group, but they're climbing. It's kind of going someplace. They're going nowhere.
Are they being helpful because they really want to be helpful?
And a couple of questions about that excerpt. In your transcript, I believe you had referred to some sort of motion made by Officer Furman as he was describing taking the driver's license and then telling someone, you're a fucking jerk, you could get out of here. Did he make some motion at that point? Do you recall this?
Yes.
Could you describe the motion he made at that time?
It would be similar to one that you would make to rip up something with your two hands.
Could you demonstrate that for us? With your hands?
I don't remember exactly how he did it, but it would be something along that line.
Pulling your
Yes.
hands apart
Pulling your hands apart, ripping something up.
as though you were tearing something.
Yes.
The transcript that we have on the video refers to officers only want to go so far, and they are not chicken up to supervisors. As I heard that, it sounded like kissing up to supervisors. Do you recall whether one word or the other was used there?
The latter would be correct.
It would be kissing up.
Yes.
Excerpt number 14.
You can't, you know why? Females are new. I've been to several calls in West LA where I'm the third or fourth car, and I end up handling the whole situation. You got a bunch of munchkins out in front with their guns. What are you doing? The call is on the other side of the house. You know, the guy broke in here, everybody's waiting where he went in. He'll go out the door, you know. I mean, it's ridiculous, you know, and they're sitting there. So I just go in, kick the door, the guy's gone out the garage, we beat the shit out of him, just a bloody mess, handcuffing, there, I'm leaving.
Thank you.
This is embarrassing. Then you go to court. They never testified. You got 5 officers in the case, I'm the only one there who knows how to testify. The DA goes, you were the 4th guy there, but would you testify? Yeah, but you didn't see, I saw it, don't worry about it, you know. Yeah, I saw it, man. Yeah, I saw it. Yeah, okay, fine. You know, why do I have to do it? That's what it's coming down to. I have to fight the guy, I have to catch the guy. I have to keep the guy's mouth shut at the station because they're not going to do it for a female. I can just walk by and go, shut up, and I'll kick his face.
In the middle of that excerpt, there was a high-pitched voice saying, "Thank you," like "Thank you." Was that Officer Furman speaking?
Yes.
What was he doing there?
He was speaking in the voice of a woman officer who would have been thanking him or any other officer that he would be describing for doing whatever he did to help.
Thank you. Number 15.
Hard working gang used to take people, you know, we'd get a murder. Sometimes 2 or 3 murders. And you know which gang did it, but they wouldn't talk. So I could pick up 3 or 4 gang members, bring them to the station, take one in the basement, just beat the dog shit out of him, not even ask him a question, bring him up, sit him down. He's bleeding, faces are all puffed up, got hurt. Next guy, take him downstairs. Okay, good shot. Where else shot him? That's how you get information. What is this patty cake shit about psychology? Oh, we got to teach officers how to speak Spanish. Now, this is America. We don't speak Spanish. No, I work Mexican. I don't know how to speak Spanish. See, how they do that? Well, they speak Spanish. No friend, they slap them upside the head. Well, they speak English. I'm an English teacher. Just like that. That's police work. And that's being able to pick out the people, that type of treatment. It's necessary.
Number 16.
Well, you have to switch up. You have to be able to look at your area and look at how you talk to people, look at how you deal with things, and what you can and can't do even with the criminal. You can't go up in Bel Air, some guy give you a hard time in broad daylight and slap you. I don't want to know what's going on, you know. You just don't do it. mean, it's obvious. But, you know, you work down the south end, metropolitan area, you work Skid Row, you use your stick more than your mouth. You know, I mean, you go first, try and tell people to go here, go there, you just use your stick. Smack them, don't move. They see no problem with that, they're where they're not supposed to be.
You know, sometimes what I see is that a lot of criminals are just as big as you, and then you get your officers that are, you know, 5'7", 150 pounds. Criminals gonna say exactly what you're saying to them.
Absolutely.
So, you know, you put back, it's, like I say, you're out
The
of
difference is it makes my job a lot harder.
Yours, personally. Yours, personally.
I think if you think it, someone from the village last weekend, this guy, I saw him the whole night getting in other officers' faces, you know, these midget officers we got. And then I went up to him and I said, move. I'm starting the street out, move. And he said, no. I just, boom, stick right in the gut. Move. You hit me with that stick, you ain't gonna do anything, boy. You wanna do something? Let's go. Put my stick away. Let's go. You know, his buddy said, let's go. Come on, you're the same size. You want to go? Let's get down. Let's get down. And he backed up. He had to get jabbed in the ribs because he's been buffaloing so many police for so long. All of a sudden, he was strong.
Yeah, well, see, if he had pulled up, he probably would have went.
Now, the female voice on that excerpt is the voice of Lori Diaz.
That's correct.
So this was the interview you had arranged to have Ms. Diaz come in and role play.
Yes.
Number 17, please.
If you don't, he's going to take it.
What kind of life or death situations have you been in?
Fights, shootings, beatings. Two of my partners were ambushed.
How did you get out of them?
Well, two guys were ambushed right in front of me. We came up after that. All the suspects ran. Both officers were down. And my partner checked the officers. They were both still alive. He called an ambulance. I ran after the suspects. And they went into a house. My partner got back to me. We went in. You know, we were just pissed. We weren't going to wait for SWAT. We just kicked the door in, grabbed the girl, put a gun to her head, her shield, walked up. They wanted to give up. Locked the door. They didn't give up. We beat them. They all went to the hospital. One died. Horrible. It's 4 and 2 straight back. So, they paid. If we could have found a gun, we would have killed everyone.
You didn't have a gun on you?
Oh, yeah. So unusual gun.
Once again, the female voice on that excerpt is the voice of Lori Diaz.
That's correct. There's a slight error in the transcript there, that where it says McKinney, that last time would be Lori Diaz.
Okay, the final comment was Ms. Diaz, not your voice.
Yes.
The last excerpt in the police misconduct offer of proof, number 18, Your Honor, is another one that we do not have audio tape for. So if you could observe this one carefully, and I'll have a few questions for you. We could have number 18. Do you recall those words being spoken by Officer Furman?
Yes.
And when and where were they spoken?
They were spoken in, I believe it was the spring of 87.
Right. And is this the interview you referred to earlier where the tape was inadvertently erased?
Yes.
This was number 9?
Yes.
I believe we
And
had
this-
some earlier excerpts from number 9. And this transcript was prepared how long after the interview took place?
It would have been prepared within a day or two of the interview.
And is the transcript an accurate record of what Officer Furman said?
Yes.
You didn't change any of his words?
No.
Your Honor, the final two offers relate to the attitude of the witness. They are excerpts from a tape that was made on July 28th, 1994, after this case was initiated and after Officer Furman had testified as a witness at the preliminary hearing. Do you recall meeting with Officer Furman in July of 1994?
Yes.
And did you tape record that meeting?
Yes.
And did you prepare a transcript of that meeting?
Yes.
And what was the purpose of this meeting in July of 1994?
I was meeting with the gentleman who had optioned the property and Officer Furman and myself. It was in part to be a story conference updating Officer Furman with what was happening with the property at that time.
And Mr. Flynn, who was he?
Mr. John Flynn, it was the gentleman, his producer, who had optioned the property, the script.
All right. When you talk about the property, you're talking about the screenplay that you wrote.
Yes, I'm talking about the screenplay.
And where did this meeting take place?
In Alice's restaurant in Westwood.
All right. So you had returned from North Carolina for the purpose of this meeting?
I returned from North Carolina for the purpose of this meeting as well as other business meetings, yes.
And did the subject of Officer Furman's role as a witness in this case, the case of People versus OJ Simpson, come up in the course of that conversation?
Yes.
If we could have excerpt D1, please.
This is irrelevant to the issues in front of the court.
Well,
You're a bill. I'm the key witness in the case, and if I go down, they lose the case. Well,
And you're that. I mean, if you are maligned,
And if we could have excerpt number 2.
well, the funny thing about it is, it's like, the attorney goes, she goes, the rest of your life, this is yours. You're bloody well.
That's it. It's one of the things that will mark the
He says you might as well make it pay off.
Yeah.
You don't make it pay off, all you're doing is going through all the heartache for nothing.
Yeah.
Like when you go for shit for everything else.
Yeah, well, I think that.
That concludes our direct examination, Your Honor.
Mr. Darden?
Just a couple more questions. Was there any arrangement for Officer Furman to receive any compensation for the role he played in assisting you with this screenplay?
Yes.
And what was that arrangement?
We had a verbal agreement of $10,000 upon the sale of the screenplay.
And was any credit in the screenplay itself given to Officer Furman for the role that he played?
He was on the title page as technical advisor, Officer Mark Furman.
All right, so the title page indicates Technical Advisor, Officer Mark Furman?
Yes.
And what does the term technical advisor have any meaning within the trade? What does technical advisor mean?
It would mean to someone in the trade that the information, the procedural information, some of the dialogue, some of the situations would be fairly accurate, and it would indicate that the writer went to some lengths to make sure that that information was accurate.
Thank you. That concludes our Zoom.
Mr. Darden?
Good afternoon, Mr. McKinney.
Good afternoon, Mr. Darden.
Doing okay?
I'm all right.
Me too. You had a financial arrangement with Mr. Furman, is that right?
We had a verbal agreement, yes.
And he was to receive $10,000 as a result of being the technical advisor in the screenplay?
Yes.
And you made that agreement when?
In 1985,
Would this be at the April 2nd meeting, or would it be before the April 2nd meeting?
it was sometime during that April to June period. I don't remember exactly when the agreement was, but it would have been sometime in June.
Could it have been at your very first meeting, the first time you met him at Alice's restaurant?
I don't believe so, no.
But when you met Mr. Furman, you told him that you were doing a screenplay, right? Is that right?
I told him that I wanted to do a screenplay about a particular situation.
Okay.
Yes.
And did you tell him that it would be fictional?
I told him that I wanted to do a fictional piece based on reality.
Did you tell him that it would be about female police officers and their circumstances, the circumstances they confront as police officers in the LAPD? Did you tell him that?
I told him that I wanted it to reflect how certain officers and who were members of Men Against Women responded to certain women in LAPD and what those frustrations the men were facing were like and what the frustrations and obstacles the women were facing as a result of that were like.
Did you make it clear to Mr. Furman that the screenplay would be a fictional piece of work?
I believe I already answered that question.
Did you make it clear to Mr. Furman that it would be a fictional piece of work?
I made it clear to Mr. Furman, who was Officer Furman, that it would be a dramatic, fictional piece based on reality.
Okay. Well, is everything contained in the screenplay? We'll strike that. You've written a screenplay, is that correct?
Yes, I have.
Is everything in the screenplay true?
I don't know if everything is true in the screenplay.
And that's because you have never done any fact-checking. That is with the exception of reading LA Times articles as they relate to Men Against Women. Is that correct?
That's irrelevant to the LA Times
Or will?
Could you repeat the question, please?
The only fact-checking you've done or did in preparation of your screenplay was in reading LA Times articles as they relate to Men Against Women?
I would try to talk with other officers about Men Against Women and see if they would tell me anything so that I knew that it existed. I was unable to obtain any details about the group Men Against Women from anyone else other than Officer Furman.
So is it fair to say then that other than the information given to you by Officer Furman and the LA Times articles, you had no other facts or sources to corroborate the things Detective Furman told you?
As well as the other information that people had given me to let me know that it existed.
Okay.
Yes.
Did you look at any official police records?
I was unable to look at any official police records. They were.
Now, during the conversations you had with Mr. Furman, he would recount to you certain events. Is that correct?
Yes.
Okay. And you never did a fact check to determine whether or not the things he told you were true or not. Is that correct?
There were certain things that Officer Furman discussed regarding women in the LAPD and the academy, and some of the changes that had been made at the academy due to the consent decree that had been signed in the early 80s that really mandated that more women be in the police departments. And so we had discussed some of the changes that were made at the academy. And
May I
yes.
interrupt you for a moment? This is non-responsive.
Oh,
Okay. May I ask another question?
you may.
Okay. Ms. McKinney, is it your impression that we are on opposing sides of an issue here?
You and I?
Yes.
No.
Okay, because we're not. Okay. But my question to you is simply this. We'll strike that. Do you recall the incident involving the 4 men in Hollenbeck area that according to Furman, were beaten by himself and 3 other officers?
Certainly.
Okay. Did you ever look at any official police records to see whether or not that event actually occurred?
No, I did not.
Did you ever review any civil suits or the civil index to see whether or not any plaintiff filed a lawsuit alleging facts resembling the facts or the information Detective Furman gave you?
No.
Now, you have heard a number of incidents recounted by Detective Furman on tape here today. Is that correct?
That's correct.
Okay. Can you recall any specific incident that is amongst those you heard here today wherein you searched a civil index for information or plaintiffs alleging facts or allegations similar to the ones we heard today?
No.
And one of the reasons you never did that is because you were writing a fictional screenplay based somewhat on reality?
That's accurate.
It's based somewhat on reality, is that right?
Yes.
And some of the more realistic aspects of your screenplay was the procedures used by the LAPD, correct?
I'm sorry, could you repeat that again?
Some of the aspects of your screenplay that are factual as opposed to fictional include things like the procedures utilized by the LAPD.
Yes, some of them are factual, as far as I would know.
Now, when you spoke to Detective Furman about the screenplay initially, did you tell him that you were hoping to write a screenplay suitable for movie theaters as opposed to a television movie?
That wouldn't have been discussed initially, but yes, I did tell him that I wanted to write a feature.
And the reason you wanted to do a feature film as opposed to a TV movie was because you wanted to make certain that the movie or screenplay was extremely dramatic, correct?
I wanted to make certain that if we were dealing about issues of whether or not women could succeed in areas of high crime, that I was accurately representing to the best of my ability what might in fact take place there. And I didn't know if that could be accurately depicted on television.
All right, Ms. McKinney, would you just sort of pull the microphone just a little bit closer to you, please?
Yes.
Bend it out a little. Super. Thank you.
Okay.
Mr. Darden.
Thank you, Your Honor. And the kinds of things that might take place include violence, of course, correct?
Yes, I was writing about an area of violent crime.
Okay. And you didn't want to do a TV movie because you were concerned that some of the violence that you thought was relevant might be cut out of a television movie. Is that right?
It wasn't just the violence. That can be adapted for television. That was a concern, but that wasn't exclusive. It was the language as well.
You wanted to make sure that any profanity that you felt was appropriate in the context of this screenplay or this movie was included in the movie. Is that correct?
That's correct.
And did that include racial epithets as well?
If appropriate, it would.
You assumed, or hoped rather, that the movie would be extremely violent. Is that right?
No, I didn't want it to be extremely violent. I wanted it to reflect what kinds of issues and situations men and women who worked in an area of high crime late at night, what kinds of situations they might encounter.
And were you concerned at all that if the movie was made into a TV movie, that the issues and the language and the violence might be watered down?
Yes.
Now, and did you tell all of this to Mark Furman? About your concerns about the issues and the language and the violence being watered down if it was made into a TV movie? Did you tell this to Mark Furman?
I don't think initially. That's something we might have discussed more at a much later date.
Okay. But you would have told him this sometime in 1985, correct?
No, not necessarily. I could have told him later when a gentleman who optioned it would be taking it to television. It wasn't something that I might have told him initially.
Okay. And now we're speaking in terms of whether you might have told him or when you might have told him at this point. Is it fair to say that you don't recall when exactly you told him?
That would be fair to say, yes.
Okay. When we spoke to you on August 17, and we did speak to you, Ms. Clark and myself and other members of my staff, is that correct?
Yes, we did.
You came to our offices and spoke to us,
Yes.
you and your lawyers,
Yes,
and you had spoken to the defense previously, is that right?
that's correct.
Okay. When you spoke to us on August 17, didn't you tell us that you had always told Furman that it was a feature because it was very controversial and quite violent?
Could you say that again, please?
When you spoke to us on August 17, didn't you tell us that you had always told Furman that it was a feature, that you were writing a feature because it was very controversial and quite violent?
I think that was an understanding that it was a feature, that I wanted to write a feature, and that given the nature of the location of Violent Division 77, that was the question is, can a woman officer succeed in a violent area of crime?
And
So
if
you knew that.
I'm sorry.
I'm sorry, go ahead.
Did you finish? Did you finish?
I'm not sure if I answered exactly your question. If you want to rephrase it, I'll try to answer it.
Well, this
best I can.
understanding, this is an understanding both you and Furman had from the beginning of his involvement in the project. Is that right?
Could we go over the parts so I'm clear for you? One, that it would be a feature, and
Two, it would be violent.
it would be that the story would take place in an area of violent crime, which, as it might develop, I would certainly want to know what kinds of situations would occur with men and women.
At some point, you learned of Detective Furman's testimony when he was asked if he had used a certain slur in the past 10 years. You learned of that testimony sometime after Furman gave that testimony?
Again, please.
Did you learn of Furman's testimony in this case regarding the N-word sometime after he gave the testimony?
I learned of his testimony, yes.
Okay. Were you watching that day when he testified?
I wasn't watching during the day, but I believe that night or shortly after I saw a snippet of it on CNN.
Okay. And when you saw his testimony and heard him testify that he had not used the N-word in the past 10 years, did you realize at that point that that was not true?
I would have realized at that point that it would probably be false.
And when you say you would have realized,
I don't remember what I thought
okay.
at that time. I don't remember what I thought when I heard his testimony.
Okay. But you learned of it that night.
Or soon after, yes. I don't know if the snippet I saw was that night or the next night.
Okay. And after learning of Mark Furman's testimony, you did not contact the defense, and nor did you contact the DA's office. Is that right?
That's accurate.
You didn't come forward with these tapes and the information you had,
That's correct.
and you didn't come forward immediately or within a few days of your learning of his testimony. Well, why didn't you come forward immediately?
The information on the tapes and the testimony on the tapes, I felt, does not directly exonerate Mr. Simpson, and therefore I didn't have a responsibility to come forth with the information. And there are other people on the tapes. I wanted to protect their confidentiality and interviews they had given to me.
Well, you could have provided the defense of the DA's office with a single tape, that is a single tape recording of conversations occurring within the last 10 years that included these epithets, had you wanted to. Is that correct?
Or we'll
So,
rephrase the
again,
question.
You could have given us a single tape, a tape containing only conversation between yourself and Mr. Furman, had you wanted to. Is that right?
Given that I wish to protect the confidentiality of the people with whom I'd interviewed on those tapes, as well as the confidentiality and the nature in which I gather information as a writer, I doubt seriously, given the enormous leaks that have occurred in the last 2 months, that I could have offered a tape to the defense or the prosecution that specifically delineated some portions of Officer Furman's testimony.
Another reason that you didn't come forward immediately is because it was your view that there was nothing in those tapes that suggested to you that Mark Furman planted evidence in this case. Is that correct?
There was nothing to me that made me feel that Officer Furman could have planted evidence in this particular case. No.
At one point today, you testified regarding proffer number 41, I believe it is, the one that relates to Farrell and this term anthrocide. You recall that?
Yes, I do.
Now, during that conversation with Mr. Furman, to put that in context, is it true that Mr. Furman was telling you about a word that some other individual had created?
I think so.
Okay. Will it help you to look at page 16 again?
Yes, it would. Thank you. Okay, now can you re-ask the question? I can answer better. Thank you.
Having looked at page 16, would you agree that to put that portion of the conversation in context, it was Detective Furman telling you about a word that some other person had created?
I think that's a possible interpretation, yes.
I think that's the appropriate interpretation?
I don't know. I don't know if he came up with that or somebody else did. I don't know.
It is under the column labeled Farrell. Is that correct?
Right.
Obviously, when you began to write this screenplay, you wrote it with the purpose of perhaps selling it someday. Is that correct?
Yes.
Okay. And the market for screenplays is a very, very competitive business, isn't it?
Yes, it is.
Okay. And was it your view at the time that to sell your screenplay that you had to make it provocative and shocking, controversial?
No, absolutely not. I think the issue itself is enormously controversial. What I was really trying to do was gather as much information as I could from different points of view to be able to dramatize the material in a cinematic fashion.
Well, you wanted to make it extremely dramatic, I think you told us.
Yes.
Now, when you spoke to Furman on April 2nd, 1985, did you already have in mind who the characters would be or might be in this screenplay?
I'm sorry, could you give me the
Did you-
dates again? In 85, you said?
Yes, April 285.
285. In the initial meeting, did I have? I missed the very date of your
Okay.
question.
Well, you met him at some point at Alice's restaurant, and then you met him again on April 2, 1985?
Okay, so we're talking about April 2, 1985, and the question is?
Okay. And by the way, that is the tape that is missing, correct?
Yes.
Yeah. Please, what was the question?
Whether or not the characters had been cast or formed at that time.
Thank you, Your Honor. When you met Detective Furman on April 2, 1985, had the characters been cast or formed at that point?
No, I only knew that I wanted the epitome of a woman officer to be transferred into an area of high crime and have to be partnered with an officer who is a member of Men Against Women.
You asked Detective Furman to help you develop those characters, some of the characters, is that correct?
Yes,
You asked him to help you develop some of the characters in his fictional screenplay based somewhat on fact.
I made it clear that I wanted him to give me ideas and some of his points of view so that I could develop the characters, and in that sense, he was very helpful in helping to develop the characters, yes.
Okay. And so you would give Detective Furman certain scenarios or situations, and you would ask him how a police officer might respond to those situations. Is that correct?
That's correct.
Okay. And you would ask him these questions in the context of a police officer whom you envisioned as being an officer who did not like having a female partner.
Correct.
And you asked him these questions in the context of a police officer who was very difficult to get along with. Is that correct?
Those would have been some of the questions. They weren't all of the questions.
Okay. And you would ask him these questions in the context of a police officer who might not always play by the rules?
Well, that was an element that seemed to present itself as the interviews progressed. I didn't know that initially.
You asked him these questions in the context of a police officer who lied on occasion, or who would lie on occasion?
Again, it's within the context of the story. The men who were involved, some of the men who were involved in Men Against Women, routinely stonewalled women, embarrassed them, and humiliated them by keeping them out of their group. And within that context, there was a certain amount of lying that went on. I was interested in that.
And Detective Furman was interested in helping you?
Yes, he was very supportive.
Could you have written the screenplay that you eventually produced without the help of Detective Furman?
I could have written the screenplay, yes. I did an enormous amount of research on the screenplay, interviewed many officers from LAPD and Los Angeles Academy. However, I would have not have had the same, there's a good chance that I would not have had some of the point of view of Officer Furman and some of the scenarios that have been recently revealed in the news were given to me by him, and I included a couple of them in the script. I abridged them significantly, but it's unlikely that I would have gotten that information regarding Men Against Women.
Is it fair to say that Detective Furman was helping you make up a story?
Helping me make up a story?
Yes, he was helping you to make up a story.
I would say it's very fair to say that he was giving me information that helped me develop characters for the story. Yes, there's a huge bulk of story of which Officer Furman didn't comment on or offer information for.
But when you testified in North Carolina at page 20, the transcript, you told the judge that Mark Furman was helping you make up a story. Is that correct?
I thought I answered that he was helping make up giving me certain points of view that then helps me make up characters. And in that light, he certainly was helping.
Okay.
Thought he gave it.
It's page 20 on my transcript. Detective Furman didn't tell you that he planted evidence on innocent people, did you? Did he?
I would have to find that in my transcripts. I don't recall a particular incident right now where Detective Furman said he planted evidence on innocent people.
You don't recall a particular incident?
No.
And the views that Detective Furman expressed on the tape, you don't know that what is reflected on the tape are his real views, or his true views about African Americans. Is that correct?
Objection, false perspective.
Oh.
Could you say that again, please?
The views expressed by Detective Furman on the tapes, you don't know that those views reflect his true views about African Americans, do you?
Objection made.
Do you understand the question?
It feels
Well,
feels vague to me, but I can answer it. It's what's on the tape is what Officer Furman said to me.
okay.
I don't know if he was lying to me, or saying anything else. It's what he said.
Okay. And so that the record is clear and there's no dispute between you and I, certainly, he used this epithet, correct, in the last 10 years. I mean, he uttered this word, didn't he?
Yes.
Now, to go back to the excuse me. The screenplay that you wrote was not a biography of Detective Furman's life, was it?
No, it was not.
To go back to the 1985 tape, the one that was lost, and this would be the first tape.
Rephrase the question.
The April 2, 1985 conversation that you had, was the tape lost? Or
No,
copied over?
I inadvertently re-recorded over it.
You say you made a transcript of that tape? Is that right?
Of the April 2nd taped interview?
Yes.
Yes, I did.
Now, you didn't begin the tape initially or immediately upon seeing Detective Furman on April 2, is that correct?
No.
Okay. You met him, you spoke to him for a while, and then you turned the tape on, is that right?
Yes.
There was conversation that you had with Detective Furman that is not on the tape, is that correct?
That would be correct.
Okay. And there were times and occasions during the conversation that you had with him when you turned off the tape, is that right?
Yes, or at the end of the discussion.
Okay, so you might discuss a particular topic or have a certain discussion and turn the tape on and then turn it off at the end of that discussion?
It's possible, especially if I was trying to protect. I only had a couple tapes with me and I was concerned about time. Yes.
Okay, and so when you say it's possible, what you're intending to convey to us is that you're not sure when and if and at what times you may have turned the tape on or off during that April 2, 1985 conversation. Is that correct?
I don't recall.
Okay. And when you transcribed the tape, the April 2 tape, you didn't transcribe each and every word contained on that tape. Is that correct?
Well, for the initial tapes, I was very judicious about transcribing my questions and Officer Furman's responses because it was a new topic and I wanted to try to understand and catch his cadences, specific situations, procedure, elements that would give me fodder and information upon which to develop this screenplay.
Okay. And so if there was other information on the tape, information that you didn't feel helped to develop the screenplay, you didn't transcribe that information?
Initially, I would have transcribed the first interviews.
Okay. And when
Yes.
when you say that initially you would have transcribed those portions of those interviews, you are assuming, correct, that you did that or would have done that?
I am assuming, yes.
How long did the April 2, 1985 interview strike that? How long did you and Detective Furman talk, speak to each other on April 2, 1985?
I'm not sure, probably about between an hour and a half to 2 hours.
And you're not sure, actually, just how long that conversation lasted, are you?
No, I'm not.
Was it during that April 2, 1985 conversation that you first heard Furman use the N-word?
I believe so, yes.
And when you heard him use that word, you did not react to his use of the word, is that correct?
No, I did not.
You did not tell him to stop using the word, is that correct?
That's correct.
You didn't ask him not to use it again, is that correct?
That's correct.
And why is that?
Again, please?
Why is that? Why didn't you stop him?
Oh, I was, as I mentioned before, in a journalistic mode, not a judgmental one. And I wanted to hear what he had to say and encourage him to feel that he could speak comfortably and use whatever words he felt appropriate.
Is that what you did? Did you encourage him to continue to speak in the tone and manner in which he had during the April 285 interview?
I didn't discourage him by asking him not to use certain words or asking him not to tell me about certain things or that I didn't want to hear about certain situations that might have occurred. Would have closed the door to really helping me understand what his point of view was regarding this issue, which he did understand I wanted to convey in the context of the screenplay. It would have been counterproductive to my research.
Now, some of the interviews you had with Detective Furman and that are on tape were telephonic interviews, is that right?
That's correct.
You were in North Carolina at the time?
No, I was not. I was in Santa Monica.
And you also told us this morning that at some point you sent Furman's transcripts of your interviews with him. Is that right?
I recall sending him one transcript, which would have been the first one. It would, and the questions, because I had written questions for him to consider answering during our next meeting. So I felt that the transcript might be useful to him in refreshing his memory to help him ponder those questions. I don't recall sending him all of the other transcripts during those 85 taped interviews independent. I don't recall sending him the transcripts independently. I think I gave them to him again all at once in a bound 3-ring binder similar to this one, which is how I filed my transcripts.
Okay. You say you think you gave those to him?
Oh, I know I gave them to him, but I don't remember exactly when, whether it was in June or early June, late June. I just don't remember if I sent him by mail any more than the first transcript. I gave the others to him bound in a 3-ring binder.
Do you know whether or not he read those transcripts?
I have no idea.
You never sent him the tapes.
No,
Have you ever given him a copy of the tapes?
no,
You never gave him a copy of the tapes before he testified at trial on this matter?
I'm sorry.
You didn't give him a copy of the tapes prior to his testimony in this trial?
No.
Is it fair to say that the only times that Furman used these epithets was in the context of his discussions with you regarding the screenplay?
Could you rephrase that, please?
Is it fair to say that the only time that Furman used these epithets was during the conversations he had with you and in the context of your discussion of the screenplay?
I can say that he used the epithets in the context, in the tapes. That is, I don't, and the taped interviews and the transcripts, I don't, that is accurate. I don't know what else to say about that. Sorry.
Well, you met with Furman during July of 1994, is that right?
That's correct.
July 28th, was it?
Yes.
And you mentioned the name of a producer who was also present at the time?
Yes.
And who was that?
That was Mr. John Flynn.
And you and Mr. Flynn had a conversation with Furman regarding the glove issue, correct?
There was reference made to the glove during that conversation, yes.
And he told you that he did not plant the glove, didn't he?
Yes.
You'd known Furman at that point for a period of 10 years, is that correct?
Yes.
And would you agree that you and he had the kind of relationship where he could be candid?
Yes.
You? One moment, Your Honor. In the context, the portion of the July 28 conversation that we've heard here today, that is that portion of the conversation where Detective Furman spoke of Mr. Shapiro. Detective Furman was talking about suing Shapiro for libel at that time. Is that correct?
I believe that was the context, yes.
Detective Furman claimed he had been libeled, slandered when Mr. Shapiro alleged that he, Detective Furman, had planted the glove in this case. Is that right?
I actually don't know why Detective Furman was libeled. I know that we discussed that, but I don't know what that issue was between Mr. Shapiro and Officer Furman.
During that conversation, Mr. Furman told you that on the night of June, or during the early morning hours of June 13, that he was just doing his job. Is that correct?
Yes.
Said that he was doing his job like he did in every other investigation that he handled. Is that correct?
Yes.
With regard to the April 2nd, 1985 tapes, throughout your testimony this morning, as they related to that particular tape, you had to refer repeatedly to your outline. Is that right?
To my transcript?
Yeah, to your transcript.
Yes.
And that's because, for the most part, you have no independent recollection of what was said during the April 2, 1985 conversation. Is that correct?
No, I don't think that's correct.
If I can have one moment, Your Honor. Page 19 of the North Carolina transcript. Let me ask you specifically about the portion of the tapes where Detective Furman talks about tearing up driver's licenses. When you testified in North Carolina, you didn't recall the Detective Furman's statements. Is that correct?
Could you refer, are we referring to the North Carolina
Yes.
hearing testimony?
Yes.
Could you repeat it then again, please?
Okay. Well, do you recall being asked this question and given this answer at line 12, lines 12 through 17, page 19? And to put that in context, Mr. Cochran here handed you a copy of your outline to refresh your recollection. Do you recall that?
I don't know where we are. I'm sorry. I don't know where we are in North Carolina. I don't know where we are here. So if we
During
could
your testimony in North Carolina,
yes.
there was an occasion where you were asked questions by Mr. Cochran about allegations that Detective Furman had torn up driver's licenses. Do you recall that?
I don't recall, but if it's on
Well,
my testimony, I'm sure I did.
Well, would it refresh your
Was that-
recollection if I gave you the transcript to take a look at? You have this, Jerry?
Yes, it would. Thanks a lot.
Let me show you page 19, lines 12 through 17.
Right. McKinney, why don't you take your time and read it to yourself?
Thank you.
See if that refreshes your recollection as to your testimony back in North Carolina.
Okay.
Okay.
I remember now. John, sorry, what's the question
And the
now?
question is this. Isn't it true that you have no independent recollection of what Detective Furman told you as it relates to the tearing up of driver's licenses?
Well, in North Carolina, when I testified to that, I needed to see it on the I needed to see it. I hadn't looked over the transcripts nor any of the information that I have discussed today. So that's what I testified. Since that time, and since having read that over in North Carolina and having refreshed my memory, I remember that element of tearing up licenses, but I needed to read it on the transcript.
Okay. So when you testified then in North Carolina, you told the judge that you did not remember what, if anything, Furman said regarding tearing up license plates. Driver's licenses. Is that right?
I needed to see it in the transcript, yes.
Okay. And you were shown a transcript,
Yes.
correct? And even after you were shown that transcript, you still couldn't recall what, if anything, Furman said in that regard. Is that right?
Well, I knew what was in the transcript, but beyond that, I couldn't say what he would have said about ripping up driver's licenses.
Okay. And is that your position today? That is that the testimony you've given us as it relates to the April 2, 1985 interview, really what you're telling us is that you transcribed the tape, here's a transcription. If it's in the transcription, then that's what he said, right?
I'm saying that I transcribed Officer Furman's words to the best of my ability, accurately, yes.
Okay, so the answer to my question, yes?
Yes.
To go back to the issue we just discussed, Ms. McKinney, is it fair to say that with regard to your recall, your specific recall of what was said during the April 2, 1985 interview, it's fair to say that you have no independent recollection of what was said, but that you only know what was said because it is on the transcript?
I really need to have independent recollection defined for me, I think, because if you were to ask me what is on each one of these transcripts, I wouldn't, aside for maybe a few that have somehow come to light, I would be hard for me to tell you what is on each transcript. But if I read it, then I remember it, I recall. It's like writing something, I won't remember that I maybe wrote it, but if I read it in one of my files, I'll remember that I wrote that. So could you define then what you mean by independent recollection, what that would mean to you, so I can be more helpful.
Let me ask you a series of questions and ask you about some answers you gave in North Carolina. At page 19, line 12 through 17, you recall being asked this question and giving this answer. Question, does that refresh your recollection that Detective Furman told you that if the suspect, the African-American suspect, gives him identification, he'll just rip up the license? Your answer was, again, if it's here, he said it. I transcribed it. I actually don't remember. It's been 10 years. Do you recall being asked that question and giving that answer?
Yes, I do.
And is it your testimony today that now your memory is better as it relates to that specific question and answer?
My memory regarding the transcript of what the transcript says is better because I have read that portion of the transcript since the testimony in North Carolina.
And so are you telling us then here today, as it relates to the April 285 transcript, what you're telling us is what is contained in the transcript and not what was actually said. Is that right? Are you with me on this?
No, I'm
Okay,
not.
Me either. Okay. What you're recalling today is what is contained in the transcript. Is that right? As opposed to what was actually said.
What I'm recalling today is what is transcribed in that transcript of mine. And I'm saying that that was what was said.
And you're saying that that is what was said because, in your view, you accurately transcribed the tape.
Yes.
Okay. And not because you know for a fact each and every word said between you and Detective Furman on April 2, 1985. Correct?
I think we almost have it. Just could you repeat that one last part? And not because...
You testifying that you have an independent recollection of what is contained in the transcript as opposed to having an independent recollection of what was said between you and Detective Furman?
Again, I would probably need to have independent recollection defined, but my understanding of it is that when I read the transcript, I can remember having those words said to me. I can't tell you everything that's on that transcript, but when I see that excerpt in the transcript, I can tell you if it was said to me or not.
Can you tell me what is not contained on the transcript? What was said that is not contained on the transcript?
You mean what would have been not taped and said?
Yes.
No.
If I were to ask you to recount everything Mark Furman said during the April 2 conversation, could you tell me?
No.
Can you tell us each and everything that was said before and after each of the notations and conversations included in your transcript?
You mean before the taped interview would start and then after the taped interview was concluded? Can I tell you what was said during those times?
Okay, let's start there. Yes.
No.
Okay. And during those occasions when you would stop the tape during the middle of your conversations and then start it again, could you tell us what was said between that time period?
No. However, it wasn't a practice to stop and start the tapes. I wanted to make it clear that I would stop them on occasion for different reasons, but it wasn't a practice to edit material by stopping and starting. I never intended for anyone to be listening to these tapes or reading these transcripts.
Is it fair to say that without looking at the transcript you prepared from the April 285 interview, well, let me put it this way. Unless you look at that transcript, you can't tell us what was said. Is that right?
I think we've asked this question now about 8 different ways.
Okay. Thank you. There were other interviews that were had between yourself and Detective Furman during April of 1985. Is that correct?
Yes.
Okay. And is it fair to say that before you could recount to us what was said, even on the tapes, you would have to listen to the tapes or first read your transcript of the tapes?
Specifically, if it's a specific instance you would like me to recall or discuss, yes. Generally, I have a clear understanding.
We'll take a break in a couple minutes.
Thank you.
We'll take a break in a couple minutes.
Why don't we put one now, Your Honor? It might hurry things along if you took a break right now.
All right, we'll take a 15-minute recess. Mrs. McKinney, you may step down and come back in 15, please. Thank you. Again, on the witness stand, still under oath, undergoing cross-examination by Mr. Darden. Mr. Darden, you may continue with your cross-examination.
Thank you, Your Honor. Ms. McKinney, when we spoke, you and I, Ms. Clark, and your lawyers on August 17, do you recall being asked this question and giving this answer? Question, and you transcribed the first tape just the same as you transcribed any other tape, right? And your answer was yes. You recall being asked that question and giving that answer?
Yes, I do.
Oh, I'm sorry.
And-
Ms. McKinney, would you pull the microphone
sorry.
closer to you?
And that was true, is that correct? And that was true, is that correct?
That I transcribed them. Yes, I was the only one to transcribe the tape.
Okay, and you transcribed them just as you had the other tapes?
I transcribed all of the tapes, yes.
The
No one
same
else?
way?
Yes.
Now, let me just ask you some questions about your North Carolina testimony, starting on page 7, line 17 through 19. So that the record is clear. Do you recall being asked this question and giving this answer? Question, that transcript that you prepared, a fair and accurate copy of,
15.
I'm sorry, line what?
15.
Yes, thank you, Your Honor. Line 15, question, did you prepare a transcript of that tape? However, answer yes. Question, that transcript that you prepared, a fair and accurate copy of what was stated on the tape? Answer of most of the things that were said on the tape, yes. Do you recall being asked those questions and giving those answers?
Was this about all of the tapes or about one in particular tape? I don't, the initial part of that question I would need to hear again.
This is regarding the first tape.
Actually, why don't you should start
Line 13.
probably line 11.
Thank
Because
you.
it's,
Can the record reflect I'm showing the witness
Thank you.
page 7 of the transcript?
yes.
Yes, thank you.
Have you read lines 11 through 19?
Yes, I have.
Okay, and is that accurate?
Yes.
That's what you testified to,
Yes,
is that
that's what I
correct?
testified to.
The first tape, the first transcript of the first tape contains most of the things that were said on the tape. Is that right?
I would say yes.
And on page 13, at line 4, You recall being asked this question and giving this answer? Line 4 through 9. Question, do you recall an instance where Detective Furman indicated to you that when he didn't have a reason to arrest someone, an African American, that he would, strike that we would perhaps tear up their license and charge them with not having a driver's license? Your answer, I don't recall. You recall being asked that question and giving that answer?
I don't recall being asked that question, but if it's there, I remember the issue of tearing up a license was something that came up.
Would you like to see the transcript?
That would be useful if you want me to say something about it. Right.
You recall being asked that question and giving that answer?
I recall needing to see the transcript when I was asked anything that was on the transcript. I needed to see it before I could comment on it.
Okay. Do you recall being asked that question and giving that answer?
Now I do, yes.
Okay. And you could not recall what was said unless you looked at the transcript. Is that correct?
I could not testify to accurately recalling unless I looked at what I had transcribed.
Okay. And that stands true today. Is that correct?
I need to look at the transcript so that I can testify to what I've transcribed. Yes.
Okay. Now going to page 16. I just confer. Line 17, page 16, beginning in the middle of the line, you recall being asked this question and giving this answer. Question, did he, on other times, tell you about implicating or fabricating evidence, things of that nature? Any application charges? Your answer, only in the context of developing a story that I can remember. You recall being asked that question and giving that answer?
No, I don't, but if it's there, I know that I was asked that.
Would you like to look at the
Thank you.
transcript?
Thank you. That's for the page. Yes, now I remember, and the following example that I give is applicable to the story.
Now, you're having some trouble recalling what you testified to just a month ago, is that correct?
It's very useful to see the transcript so that I can see in what context the questions were asked and how they were answered.
And is that because by looking at the context or reading about the context in which questions were asked, that will help stimulate your memory?
Could you say that again, please?
Does that help stimulate your memory? That is to see and hear in what context questions were asked and answers were given?
Yes, it does.
directing court and counsel to page 18, line 16 through 21. Do you recall being asked this question and giving this answer? Question by Mr. Cochran. Strike that. To put this in context, do you recall Mr. Cochran asking you what, if anything, Furman told you he would do if someone called him a motherfucker? You recall being asked about that in North Carolina?
I would appreciate seeing the transcript.
Will this help refresh your recollection?
Yes, it would. All right, thank you very much.
Do you recall Mr. Cochran asking you whether or not you recalled Furman telling you that if someone called him a motherfucker, he got a traffic warning?
Yes, I recall Mr. Cochran asking me that.
Okay. And when Mr. Cochran asked you that, you responded at line 19, answer, I don't remember it, but if it's on the transcript, it was said. I transcribed it. No, I don't remember it. Do you recall being asked that question, giving that answer?
Reading it, I would say that the transcriber transcribed my words, and although I don't remember all of them, I'm sure that's accurate.
You surrendered the original tapes to the court, is that correct?
Yes.
Now, just a few more questions, if I may. Now, if I were to show you the transcripts you prepared, transcripts of the tapes, you couldn't tell me what was missing from those transcripts, is that correct?
The transcripts of if you were to show me the transcripts of my tapes,
Yes.
my transcripts of the
Yes.
tapes, I couldn't tell you what was missing.
Okay. And those transcripts weren't prepared for court, and they weren't prepared for purposes of accuracy. They were prepared to help stimulate your recall of what was said between yourself and Detective Furman. Is that correct?
Partially correct. I tried to prepare them as accurately as possible to maintain dialogue, situations, and procedural information in a sequential fashion so that I would be able to write it cinematically. That would have been critical to me.
Okay. But they weren't prepared for purposes of court, correct?
They were not.
And you weren't under any duty to anyone to prepare an accurate transcript of the April 2, 1985 tape, correct?
No,
Okay. And there's a second tape that was taped over or is missing now. Is that right?
that's correct.
And which tape was that? Do you recall?
I believe that's tape number 9.
Okay. And you were under no duty to anyone to create an accurate transcript of that tape. Is that correct?
That's correct.
The only things that you put into those transcripts were the things that were of interest to you as a screenplay writer. Is that right?
I didn't hear that last
Sorry, the
year.
only things that you put into the transcript were those things that were of interest to you as a screenplay writer. Is that correct?
That's correct.
Okay. Now, with regard to the tapes in this case, does Detective Furman have a financial interest in the tapes?
Objection, irrelevant.
Oh,
So the question is again, please?
Does Detective Furman have a financial interest in the tapes?
Objection, also legal.
oh,
To my knowledge, no, he has no interest in the tapes.
And have you attempted to sell those tapes?
No, I have not.
Has anyone on your behalf attempted to sell those tapes?
Again, please, I'm not understanding still.
Has anyone acting on your behalf attempted to sell those tapes?
The tapes are not for sale. They have not been for sale.
And how about the transcripts that you prepared of the tapes? Have you attempted to sell those?
The transcripts have not been for sale.
I'm sorry?
The transcripts that I prepared of the tapes have not been for sale.
Okay. And has anyone on your behalf, acting on your behalf, attempted to sell those transcripts?
No one, to my knowledge, on my behalf, has attempted to sell those tapes.
And that would include these two gentlemen here, Mr. Regwan and Mr. Schwartz?
That would include Mr. Regwan and Mr. Schwartz.
And so if I showed you a confidentiality agreement that related to the transcript and the tape, signed one by Mr. Schwartz and the other signed by Mr. Regwan, you would be surprised to see that.
My understanding is that the tapes and the transcripts have not been for sale. So in terms of any confidentiality agreement, I don't, you'll have to show it to me.
Mr. Ullman, any redirect?
Very brief. Ms. McKinney, the hearing that took place in North Carolina was with respect to the enforcement of the out-of-state subpoena, is that correct?
Yes, it was.
And before you attended that hearing, did you have an opportunity to review the transcripts?
I didn't review the transcripts.
Did you listen to the tapes?
No.
So the questions that were asked in that hearing were presenting you with transcripts and information in the transcripts cold or without any preparation on your part. Is that correct?
That's
Oh,
correct.
Now, the questioning in that hearing with respect to Officer Furman tearing up driver's licenses. Actually, in the transcripts and tapes, there are two references to the tearing up of driver's licenses, are there not?
I remember one now.
All right, well, let me refresh your memory. One occurs in transcript number 1, and it is contained in our offer of proof as item C2.
Counsel, what's the purpose of this?
Well, I believe the questioning in the North Carolina proceeding related to a different driver's license tear-up
Counsel, I've
than
read
the
all
one
this
that
stuff.
she testified to
I've read
here.
it all. I've listened to it all. I'm
Right.
aware that there are two different incidents.
I won't burden the court then. With respect to the testimony in North Carolina about implicating or fabricating evidence, the testimony that Mr. Darden showed you indicated that you testified, he told you about implicating or fabricating evidence only in the context of developing a story that you could remember. Is that correct?
Yes, that's correct.
And did you, in that proceeding, describe one example where in the context of developing a story, Detective Furman did tell you about how evidence could be fabricated or manufactured.
Could we go over that again? I think I was thinking ahead. I was thinking of the example that I gave.
Let me ask if you gave this
want.
testimony on page 17 at line 13. I needed to know from Mark how two officers who transported the suspect would cover up that information so that they would say that they were someplace else. As evidence from the arm of the suspect himself as planting evidence.
Overruled.
In that response, no, I wouldn't. If you edified me to regard those kinds of activities as planting evidence, then I would rethink.
Now, Mr. Darden asked you whether you made any independent checks of records to corroborate the information that Officer Furman was giving you. Did he ever offer to give you access to any police records?
Officer Furman?
Yes.
No.
At one point, he boasted of having 2,000 to 3,000 pages of investigations in internal affairs. Was it your understanding that you could just go down to internal affairs and ask to see those records?
No.
In fact, you knew enough about internal affairs to know that those records would not be available to you, didn't you?
Yes.
Overruled. Answer standing was leading.
Now, with respect to the realism of the language that was used by Detective Furman, you were not asking him to assume a role other than himself in his conversations with you, were you?
Overruled.
On occasion, I may have asked him, what would this person say in the given instance, and he would tell me what someone might say in that situation.
Right, and those occasions would be indicated in the context of your conversation.
Sustained.
And would those be situations where you were talking about a particular character and how you wanted to portray that character?
I was generally very specific about the situations and the character, whether it was something that the male officers would be saying in the locker room or something that would be happening at a particular situation where there would be only men, or something procedural, something in a car. It was specific.
And those occasions occurred as you actually developed a finished screenplay. Is that correct?
It would be easier for me to ask those specific questions the more I knew about the story and the characters, yes.
Now, on at least one occasion, in the taped conversations, where we still have tapes, there was a conversation with Detective Furman about the nature of the language that was being used. Was there not?
Yes, there was.
All right. That was in the context of tape number 4. Would that have been the 4th conversation you had with Detective Furman?
It might have been the 4th taped interview.
All right. And let me ask if these words were spoken in the context of that interview. I'm referring to page 1 of tape number 4. You stated, "I just transcribe you." And Detective Furman responded verbatim. And you replied, "I have to." And he said, all the cocksuckers, everything. That's important. That's policeman's talk. And you said, it's life talk. It's not just policeman's talk. And he said, but we have mastered it. No, the Marine Corps mastered it. Did that conversation take place?
Yes.
So he was aware of your need to have real life language just as police officers normally talk.
Yes.
And that's what you thought you were getting.
Yes.
Later in that same interview, let me ask you if this was said. I'm quoting you, and this is on page 12. Exactly. Look, Mark, all we're really trying to do, first of all, the premise is real clear. And none of the research that I do, no matter what I'm doing, riding along, spending the night in Watts, it doesn't change the premise. It's just that this kind of story is so controversial that it has to be so well documented that you get enough other people's point of view so that if somebody calls you on it, you say, yeah, I did that. I heard what they had to say. I was there. And Officer Furman replied, yeah, the only thing is, are they telling the truth? And you replied, it's their truth. And he asked, how do you prove it? And you replied, you perceive things the way you perceive them due to your frame of reference, background, and learned experience. Same with me, same with Joe. Did that conversation take place?
Which transcript are you referring to, Counsel?
Transcript number 4.
You're reading
Tape
it
number 4,
at
page 12.
What you just read is not on the transcript that I have.
It's in our offer of proof, Your Honor. Let me retrieve the transcript.
Well, I have here the transcript. You provided me with tape 4, and that is not the passage that's there.
You can stir it up.
All right, well, let's not waste time on this issue. Let's move along.
Do you recall that conversation taking place?
Yes.
That concludes our redirect.
Any recross? Ms. McKinney, my understanding of the storyline then is that this was a woman officer who was going to be transferred into 77th Division and then partnered with somebody who's a member of Mao, correct?
That's correct.
Was there a subplot regarding racial conflict amongst police officers?
No.
You indicated that in discussing these matters with Mr. Furman, that you didn't confront him on any of the items that he might have mentioned to you that you personally found offensive, that you wanted to establish a level of comfort and I take it a level of candor in your discussions. Is that correct?
That's correct.
All right. Did you make any representations or agreements with Mr. Furman regarding any confidentiality concerning these tape recordings or any of these interviews?
My feeling was that the extent of confidentiality was implicit in our agreement, as were the agreements that I had with others who interviewed with Officer Furman.
And what's the current status of the screenplay?
It is with my agent in Santa Monica.
All right. Is it still being, has anybody picked up the option?
It is not optioned as of now. No.
All right. Thank you. All right, counsel, any questions in light of the court's questions?
Your Honor, the reference that I was quoting is on page 12 of the tape transcription from lines 8 to 18, and it appears in the McKinney transcript, that is her transcript, at page 15.
All right, but what you were reading on the page 12 that I have was something different. It's about 80% the same, is my concern. So maybe you have a different transcript than what I have, what I've been working with here, which causes me some great concern.
Okay, I can tell you that what's in the offer of proof was prepared from the McKinney transcript, and we now have a separate transcription of the tape, which you have.
Okay. All right. You're just determined to make my life more difficult than it has to be, aren't you?
Not on purpose.
All right, anything else for Ms. McKinney?
Nothing.
All right, Ms. McKinney, thank you very much. Your excuse.
Thank you.
All right, any other witnesses?
No.
All right, I'll hear argument. I'm sorry? Yes, I've just excused her.
Well, not excused.
Just outside.
Yes.
Your Honor, in approaching the issues that these... Oh, I'm sorry.
Yep.
Wait.
All right, Ms. McKinney is withdrawn from the courtroom. It's a public hearing, counsel. Proceed.
At first blush, there may seem to be a remarkable similarity between the issues that we're litigating with respect to these tapes and the issues that were raised regarding the evidence of domestic violence in which the court ruled on 59 different individual items of evidence. And,
My recollection, it was 74.
74. I'm reminded of Yogi Berra's famous aphorism that is deja vu all over again, and perhaps it's a comment on the duration of this case that we're having deja vu experiences in the course of litigating these issues. But I would suggest there is one very crucial difference between what we litigated then and what we are litigating now, and that makes all the difference in the world. In that context, the prosecution had only one argument, and that argument was based on Evidence Code Section 1101B with respect to the admissibility of prior similar acts. There was no question in the context of any of that evidence of the credibility of the defendant. And of course, Your Honor's ruling did not address the potential use that could be made of that evidence to cross-examine the defendant or as extrinsic evidence to impeach his testimony if he testified. So I think it's important at the outset that we recognize here the evidence has at least two purposes, and in many cases more than two. We are talking about double-barreled evidence, or in some cases triple-barreled evidence. It is offered not just to prove conduct, that is, to support the inference that Detective Furman would have altered or moved evidence in this case or presented perjured testimony in this case. More important, it is being used to challenge the credibility of a witness who has testified, to assist the jury in assessing his credibility and the weight that they should give to his testimony, all of his testimony, not just the evidence or testimony he presented with respect to the finding of the glove. And I think it's important to put ourselves in the position of the jury looking at the testimony of Mark Furman. I know that's hard after we've read all of these transcripts and listened to all of these tapes and come to the sickening realization of who Mark Fuhrman really is. Los Angeles' worst nightmare, probably the greatest liar since Ananias. But the jury has only seen a very polished and professional performance that was carefully orchestrated, in which Detective Fuhrman sounded more like a choir boy. In one of the tapes, he says, "I'm the only one who knows how to testify." Well, I think he certainly proved that in this courtroom. He flatly and unequivocally denied harboring any racial bias. He said he had not used the word nigger in 10 years. And most important, he said that those who said any different were liars. All of them. And he was confronted with the statement of Kathleen Bell that in 1985 or 1986, precisely at the same time that these meetings with Ms. McKinney were going on, that he stated he would find a reason to arrest a mixed couple that he saw in an automobile, a black person with a white woman. He would stop them, and if he didn't have a reason, he would find a reason. And he went on to say that he believed that all African Americans should be put in a group and burned. And he denied making those statements, in effect labeling Kathleen Bell a liar. And he did it in a very convincing and persuasive manner. Now, items B1 through B41 of our offer of proof include 41 instances in which Detective Fuhrman uttered the word nigger, all within the past 10 years, and there can be no doubt about that. There's no question, but that those words were not inserted into transcripts by Ms. McKinney, unless they were said by Detective Fuhrman, and of course we heard those words being used repeatedly on the tapes. All but 15 of the 41 instances are recorded on audio tape, and those that are not are in verbatim transcripts. Of these 41 references, 31
Do you
were
feel
in...
it's fair to characterize these transcripts as verbatim?
Yes. With respect to the words used by Detective Fuhrman, absolutely, and
Well,
particularly...
verbatim transcripts in a legal context have a very specific meaning. I don't think you mean that.
Well,
You may be
obviously,
sub-
she was not transcribing them as a legal reporter to certify that every word that every word that was spoken was transcribed. And in fact, she admitted
listening to
that...
these tapes and comparing them with the McKinney transcripts indicate that there's substantial inaccuracy in those transcripts. So I don't think it's fair to refer. I don't think you should refer to them as verbatim transcripts because I think you overstate the case.
Well, I don't think substantial inaccuracies is a fair characterization either, Your Honor. The substance of what was said in every case is accurate. Where we have the tapes and can compare them.
Luckily, we have the tapes as to all but 15.
As to all but 15.
But that's sort of a warning that if you expect, I think the court, let's assume that I'm going to allow some of this. It'll only be with an accurate transcript.
And I think with respect to these uses of this word, we have an accurate transcript. We have the word being used in the context in which it was spoken, and we can with certainty conclude that the word was actually used, that Ms. McKinney would not inject this word if it had not been spoken and did not appear on the tape recording. I think it's also useful to sort out the temporal proximity and frequency of these words. That is, that 31 of these references are in 1985, 4 are in 1986, 5 are in 1987, and 1 is in 1988. And to remember that the numbers are not a reflection of some sort of mellowing on the part of Detective Fuhrman, but simply a reflection of the nature and the duration of Ms. McKinney's interviews. She conducted the most extensive, the longest interview process in 1985. The interviews that took place in 86 and 87 and 88 were of shorter duration, and that alone explains the frequency of the use of this word. And the use of the word, it's clear from the context, is not inadvertent, the kind of thing that one might forget. In fact, I think it's very important that Laura McKinney sent Officer Furman copies of the transcripts in which these words appear. So he had an opportunity to look at them. In fact, his attention was called to particular references in the first transcript, and that is the first one, number 1, where the tape is missing. He had a copy of that transcript, and he had a list of questions that referred to specific passages in that transcript.
Very similar to the civil process with depositions.
So he knew what was in there. Now, it's arguable, I think, and Ms. McKinney recognizes that and concedes that in only 2 of these instances, when the word was spoken, was it in the context of talking about a character in the screenplay, and those are B12 and B15. And the prosecution will argue, I'm sure, that where the word is spoken in this context, it should not be admitted in evidence. We believe that is a question for the jury, not a question for the admissibility of the reference, because the testimony that we are impeaching of Detective Furman was a flat denial of ever using the word without any qualifications. He didn't say, well, the only time I've used that word was speaking in a fictional context. So if we're going to put that kind of spin on the use of the word in any of these 41 instances, that's a question for the jury to decide as to whether that would be a context that would be within the scope of his flat denial of having ever used the word. So we believe that all 41 of these references, of these uses of the word, are directly relevant as impeachment evidence to directly contradict Detective Furman's testimony. But with respect to 17 of the examples, and that's the list that we provided to Your Honor this morning, we contend they are relevant for a second purpose as well. And that purpose is as evidence of Detective Furman's racial bias against African Americans. These 17 examples go beyond simply using an offensive epithet. They express overt hostility towards African Americans. They imply a judgment that people are of lesser value if they are black, that people can be treated differently because of their race. And that kind of racial bias and hostility goes directly to his credibility in terms of bias and prejudice. And we believe it's precisely the kind of bias and hostility that the court was speaking of in the case of In re Anthony P. And we cited the quotation from that case in our brief, in which the court makes the point that expressions of racial hostility don't necessarily mean that a witness would come in and give false testimony against a person simply because of their race. But by the same token, the court can't keep out those expressions of hostility by making the judgment, well, this witness's testimony is credible anyway, and I don't think the jury would discredit it based on these expressions of racial hostility. What the court in Anthony P. is saying is that these are questions of credibility for the jury to resolve. It's for the jury to determine whether these expressions of bias and hostility would infect the testimony of a witness so that they should mistrust that testimony, so that they should disbelieve that testimony. And that, of course, is a process quite apart from the direct impeachment of showing he used the word when he didn't. Here we're saying this is extrinsic evidence that he is biased, that he has hostility toward people of the African American race, and that hostility could and did, in this case, infect the credibility and believability of his testimony. Now, among these 17 examples, we contend there are 7 that are especially relevant for even a third purpose. Not only do they contradict Detective Furman's denial that he had used the word, not only do they prove his racial bias and hostility, but they give strong corroboration, independent corroboration, to the testimony of Kathleen Bell. Miss Bell's account of her meeting with Detective Furman in Westwood in 1985 or 86.
Redondo Beach.
Redondo Beach. I'm sorry, I stand corrected. That testimony was attacked even before she walked into this courtroom. The prosecutor, Miss Clark, on the record, labeled this a fantasy cooked up by the defense. And Detective Furman on the witness stand flatly denied that it occurred. And indeed, without these tapes, it does sound a little bit implausible that on practically their first meeting, an LAPD officer speaking to a woman he barely knew would frankly admit that he would make up a reason to stop a mixed-race couple, and that African Americans should be all put in a group and burned. Well, that conversation was not in the context of developing a screenplay. And yet the credibility of Kathleen Bell's account can hardly be doubted after hearing the Furman tapes or reading the transcripts of what he said to both Miss McKinney and to Miss Diaz. And it's important that those statements are exactly contemporaneous. That is, they were made at precisely the same period of time that Kathleen Bell asserts she heard these remarks made by Detective Furman. These 7 statements are of a very similar tenor to what was said to Kathleen Bell.
All right, and for ease of referring back to these, which of these incidents are you referring to as these second categories?
First of all, it would include item 4, item 12, and item 35, because these are 3 instances in which, very similar to the statement about finding a reason to stop a mixed-race couple, he indicates he would use race as the basis to stop someone. He refers to stopping someone in Westwood the night before because they were from 22nd and Western, and they didn't know where a particular restaurant was in Westwood. End of inquiry into the car. Number 12, talking about whether you need probable cause to stop 2 what he referred to as niggers. He said, probable cause, you're God. And the Porsche incident, where he talks about seeing a black person driving a Porsche who wasn't wearing a $300 suit, you would immediately stop them. So it's the same kind of tenor as the statement made to Kathleen Bell at approximately the same time. In the second category, and this would include item 5, item 6, and item 40, he is actually talking in genocidal terms about...
All right, I asked you about the third category, in the third category.
All right, yes, that's what I'm saying. All of these 6 incidents, 4, 12, and 35, relating to arrests without probable cause, 5, 6, and 40 relating to genocide, which I think are very much the same tenor as a statement to Kathleen Bell about putting people in a group and burning them. In one, he says the black people on the city council in Los Angeles should be lined up and shot. In another, he refers to spending money to keep people in Ethiopia from starving to death as being a waste of money. And in item number 40, the reference to the building of a new precinct station, or new station in Division 77, that the old station should be preserved because it has the smell of niggers who have been beaten and died within the premises of those walls. And there's one other we would put in this category, number 7, and that's 28. 28 because it is addressed directly to Lori Diaz, another woman he had just met for the first time, in which he says to her, you're talking shit. You sound like a nigger, you're talking shit. The fact that he would speak that way to a woman he had just met for the first time speaks volumes about whether he would address comments of this tenor to Kathleen Bell in Redondo Beach at approximately the same time, 1985 or 1986. Now, moving on to the second category of our offer of proof, which is subdivision C, items C 1 through 18. It's important, again, to remember that this evidence also has two purposes. It is not just to prove conduct under Section 1101B, but also to attack credibility. Now, the prosecution argument in their brief is that many of these excerpts are statements of attitude, so they don't really qualify as acts that would be admissible under 1101B. We believe, first of all, that's an inaccurate characterization, that in most of these incidents, Detective Furman is describing conduct. In most cases, his own conduct. In other cases, the conduct of other officers that he observed and approved of. But even attitude, I mean, even to the extent these merely show his own attitude, it is highly relevant to challenge his credibility, because Section 780J of the California Penal or Evidence Code, in laying out the grounds upon which credibility may be challenged, includes, as subsection J, the witness's attitude toward the action in which he testifies or toward the giving of testimony. And I think it's important that 1101B underlines the point by saying in 1101C, nothing in this section affects the admissibility of evidence offered to support or attack the credibility of a witness. So we're talking about two completely independent grounds for the admission of evidence. 1101B, when we're offering conduct to prove similar conduct on a later occasion, and 780J, when we're talking about the attitude reflected in these descriptions by Officer Furman and how that relates to his attitude toward the giving of testimony in this case. These incidents, every one of them, provide fertile ground for further cross-examination of Detective Furman about his attitude toward the giving of false testimony and the planting or manufacturing of evidence. Whether we call it an attitude, a philosophy, an MO, or just call it unmitigated gall, we now have a good faith basis contained within these tapes and transcripts to put Detective Furman back up on that witness stand and ask him, Detective Furman, have you ever destroyed evidence? No. Well, what about the driver's licenses you were talking about in these tapes and transcripts? Have you ever criticized LAPD officers because they wouldn't lie? No. What about your partner, who you said had more morals than he had hair on his head because he wouldn't lie? Have you ever manufactured evidence? No. What about the occasions when you scraped the scab from an addict so that you would have fresh blood to justify an arrest for being under the influence of a drug? And I think that's particularly relevant in the context of a case where we're talking about blood evidence. Do you believe, Detective Furman, that police should play by the rules? Yes? Well, what did you mean in these tapes and transcripts when you said, fuck the rules, we'll make up the rules later? Detective Furman, did you ever testify to events you did not observe? No? What about that incident you described when you were the fourth car on the scene and you came in and testified because, quote, you were the only one who knew how to testify? I'd go on and on. Do you believe you have some special ability to sort out good people from bad people on the basis of where they live or the color of their skin? We have the switch hitter description. Do you believe police officers should never testify against each other? How else do you explain the references in excerpt C9 to the group being tight and getting away with something that you knew they had done because the group all told the same story without even having to consult with each other?
Well, speaking of C9, would you address the argument that the prosecution raises regarding factual bases for some of these?
Yes, Your Honor. To the extent that they are going to argue that these incidents should not be admitted because Detective Furman has a tendency to exaggerate, to puff, to put in details that did not happen. That may be a fertile area of inquiry with Detective Furman, but we believe in the record we already have, there's ample corroboration of the basic facts that he's describing. In fact, one particularly telling example of that kind of corroboration can be found in the very psychiatric reports that were prepared when Detective Furman applied for a disability. And these are the terms in which he described this same incident in 1982 when he is going to the police department and saying, I want to be relieved on the basis of a disability. He said, I had 2 friends shot by a bunch of those slimes. He rose a beef for 18 months regarding what happened to 4 guys that he and his partner caught. He says he was smarter than the people who investigated this incident. He says, quote, you don't see, you don't remember, and it didn't happen. Those are the 3 things you say, and you stick to it. So that's his account of this incident in 1982, 3 years before these tapes were ever made. So there's plenty of corroboration. I believe we can show that in the essential details with respect to covering up, there is corroboration.
How are we going to do that?
Well, first of all, we can do it with the inquiry of Detective Furman on cross-examination.
Given the very rapid-fire cross-examination that you suggested, and which, if it happens, I would like for you to do it, since you seem to be able to do it in a very quick manner, Mr. Ullman, do you think counsel representing Mr. Furman would allow him to testify in light of that proposed line of questioning?
That is a bridge we will cross when we get to it. We intend to call Detective Furman to the stand. We believe, I know that he was not excused. He is subject to further cross-examination. If he does invoke the Fifth Amendment, that simply means he is now no longer available as a witness. Once he's no longer available as a witness, every one of these items becomes admissible as a declaration against interest under the evidence code, and we believe we can offer it extrinsically to impeach his testimony. We can offer it to show the pattern of conduct under 1101B. We can offer it to show habit under 1105. And if they want to come in with some counter evidence saying, well, this stuff isn't all true, Detective Furman was lying or exaggerating, they're welcome to do that. In fact, I'm looking forward to hearing that argument addressed to the jury, for the prosecution to get up and say, ladies and gentlemen, all of this stuff you heard on the tapes of Detective Furman admitting that he lied, that he planted evidence, that he tore up driver's licenses, you shouldn't trust that, because Detective Furman exaggerates. So just ignore that and believe his testimony on the witness stand, as though his tendency to exaggerate had nothing to do with the testimony he presented when he got on the witness stand and testified in this case. That's an argument I look forward to hearing, because I think we'll have an answer for it. So it's not a question of we can't let any of this in unless we have independent evidence showing that it actually happened. We have here the statement of the witness himself, in which he is recounting it. And to the extent that the prosecution wants to undercut it, to challenge it, to say it's an exaggeration, to show that some detail is not accurate, they're welcome to bring that evidence in and present it and argue it to the jury. Now, apart from the attitude.
But just, shouldn't I be concerned, though, that then I have to try 18 little trials? Shouldn't I be concerned with that?
No, I don't think Your Honor should be. Number one, it's very unlikely that we're going to see that kind of evidence brought in with respect to all 18 of these incidents. I think for the most part, the description that we have culled through the editing process from these transcripts is a very precise description. It's not going to occupy a lot of detours or false pursuits in terms of litigating the accuracy of every one of these incidents. What's relevant is not just whether they happen, but the attitude they reflect on the part of the witness. The fact that he is personally boasting about engaging in this kind of activity says a lot about the credibility we should give to the testimony he presented from the witness stand about what happened in this case. And bear in mind, Your Honor, that Detective Furman was on the witness stand, I believe, 6 days. Was it a total of 6 days? It was close to that. It was a major part of the prosecution's case. It's the foundation for the most significant evidence that they've presented against the defendant in this case. So to be concerned that with one or two of these incidents, we may have some evidence that they want to bring in challenging the accuracy, let them make a proffer of what challenges they have. And I hope it's a proffer that's better than the one they offered in their brief, which was simply a citation of the Los Angeles Times. If they have some evidence to challenge the accuracy of any of these incidents, let them offer it, and then Your Honor can make an assessment of whether indeed that will take us off on a tangent that would consume too much time. Now, let me quickly address the 1101B issue, because here again we are on that familiar terrain that we trod in the context of the earlier motions litigated in this case. Apart from the attitudes on the part of Detective Furman reflected in each of these 18 police misconduct excerpts, they are relevant to prove motive, opportunity, intent, preparation, plan, knowledge, identity, an absence of mistake or accident. And we believe that any evidence allegedly collected or observed by Detective Furman should not be trusted in this case because on prior occasions he has destroyed evidence, ripping up driver's license. He has planted evidence, including fresh blood from the scab of a hike. He has testified falsely, making up probable cause, testifying to events he did not observe. He has beat suspects in order to obtain confessions. He has ignored department rules and regulations. He has covered up the misconduct of other officers. These are all specific instances of conduct that are relevant to show his intent, his motive, his opportunity, the lack of mistake or accident, all of the items listed under 1101B that permit the admission of this kind of evidence. There are 6 incidents that we believe are relevant for a third purpose, not only to show attitude, not only to show 1101B conduct being repeated, but for the third purpose of showing habit or custom under Section 1105. And there's an important difference between 1105, Your Honor, and 1101B, because 1101B does talk about the admission of evidence that a person committed a crime, civil wrong, or other act. But 1105 says any otherwise admissible evidence of habit or custom is admissible to prove conduct on a specified occasion. And that means it doesn't have to be evidence of an act. It can be evidence of an admission. It can be evidence of a practice, or it can be evidence of a specific incident or act. And we believe that the most chilling of the incidents of police misconduct that we have culled for purposes of the offer of proof are when Detective Furman talks about how it really works and how it has worked in the past, especially item C9, where he talks about how I got away with it. I got away with it. They knew I did it, but I got away with it because we were tight, because 37 officers from that division told the same story without having to call each other up and consult each other. What he's describing is what we will contend is the code of silence. And he identifies it in even more chilling terms in item C10, when he talks about his disgust with a partner who won't lie for him. If he's not describing in that excerpt a code of silence, I don't think we could find a better description of the code of silence, of the understanding that police officers cover for each other. And the reason this is particularly relevant in this case is because the prosecution's argument with respect to the planting or moving of evidence by Detective Furman is it couldn't have happened because there were other police officers around. So they're going to argue to the jury to reject any suggestion that there could have been any tampering with evidence by Detective Furman simply because there were other cops around. Well, when this same cop gets on tape and describes how police officers cover for each other and lie for each other, we believe that's relevant in terms of how the jury is going to assess this explanation. It couldn't have happened because there were other officers around. There are also references to covering for each other in item C6, where he talks about being able to kill someone if you have a partner like a brother. Item C14, item C1 and item C13, both of which he specifically refers to how he describes what he did or how he conducts himself, depending on whether there are witnesses present or not, and applies two different standards if there are non-police third-party witnesses present observing what he is doing and how that affects how he describes what he is doing. So we believe these 6 items, C9, C10, C6, C14, C1, and C13, are all highly relevant under 1105 as evidence of habit and custom. The final category in our offer of proof goes directly toward Detective Furman's attitudes towards his testimony in this case, attitudes that we inquired into on cross-examination, asking him whether he realized the importance of the glove to this case, what kind of preparation he went through in order to prepare him to testify in this case. And here, virtually contemporaneous, just before the beginning of the trial in this case, we have him in taped statements directly addressing his role in this case, describing himself as the most important witness in the case of the century, and that if he goes down, the case goes down. Describing himself as Bloody Glove Furman, and suggesting that if he's going through all of this agony, he should make it pay, that there should be some payoff for him from what he is experiencing as a witness in this case. Finally, Your Honor, I want to address the 352 arguments. And I believe that these are arguments the court has already addressed. When Your Honor directed the parameter of the cross-examination that would be permitted of Detective Furman in the first place. And at that time, Your Honor heard the arguments about how a jury might react to this evidence, and ruled by limiting the cross-examination of Detective Furman, but recognizing that this was not an issue that could be avoided, and that we can trust, indeed we must trust the jury to treat this evidence appropriately and not overreact because of the inflammatory nature of the evidence. We believe we've been very sensitive to that. We took 13 hours of very, and Your Honor listened to all of them, very inflammatory tapes, something in there really to insult everyone. And we very judiciously edited it to a bare minimum, to a tape that the tape itself takes less than an hour to play. So we're not trying to capitalize on this. The 352 arguments about how the jury might react to this evidence are an especially strong deja vu experience for me, because they're the same arguments I made on the other side when we were arguing that Your Honor should keep out the evidence of spousal abuse, that Your Honor should keep out the gruesome autopsy photographs. And we were arguing, well, there's a risk that this evidence will be used for the wrong purpose, that it will be used as evidence of bad character to show a propensity on the part of Mr. Simpson. And Your Honor, it's important, I think, that risk, where that risk exists, is much greater where the evidence is offered against the defendant who's on trial. And the risk of prejudice is that this evidence may be wrongly used against him, then the risk that's presented when we're talking about a mere witness who is testifying on the witness stand, and the risk in terms of personal risks to him are simply not of the same dimension as the risks for the defendant who is actually on trial. At that time, Your Honor expressed confidence that the jury is capable of following the instructions, of using the evidence for the limited purpose for which it is admitted, and we believe there is no reason not to have the same confidence in the jury with respect to this evidence. Your Honor concluded, for example, in the context of the gruesome autopsy photographs.
Mr. Ehrman, I have to tell you that one of the most unconvincing lines of argument as a judge is comparison with prior rulings and mixing apples and oranges. I think the closer comparison of your 352 argument is this court's ruling January 20 regarding Kathleen Bell and the confidence that I had in the jury that if we had to use the racial epithets, if they came in an appropriate context. I mean, those are the rulings that are similar in the same context. Autopsy photographs are interesting, not relevant to this argument.
All right, I won't press the point.
And not helpful to me.
The only analogy I was seeking was that we don't reject evidence because it is painful to look at. And Your Honor noted that. Murder is ugly. Jurors have to face it. They have to confront it.
Racism is ugly.
Racism is ugly. These tapes are ugly. These transcripts are ugly. Furman is ugly. And I would hope that if any good comes out of the painful process of this trial, it is that we confront that ugliness, that we look it in the face and we deal with it. And we think the jury is capable of doing that.
Madam Reporter, how are you? Small? All right. Okay, we'll take a court reporter recess. We'll take 15. All right, back on the record in the Simpson matter. All parties are again present. I'll hear from the people.
Thank you, Your Honor. Let me begin by saying that the content of these tapes is so repugnant and so offensive that this may well be the most difficult thing I've ever had to do as a prosecutor. I don't think that there is anyone in this courtroom, in this county, that could possibly envy me. And I'm talking about any prosecutor or perhaps any defense attorney. And as a citizen, I am deeply offended, and I'm shocked, and I'm disgusted with what I've heard. But I cannot afford the luxury of being Marcia Clark the citizen. I am Marcia Clark the prosecutor, and I stand before you today, Your Honor, not in defense of Mark Furman, but in defense of a case of such overwhelming magnitude in terms of the strength of the proof of the defendant's guilt, that it would be a travesty to allow such a case to be derailed with a very serious and important but very inflammatory social issue. And what has occurred, and what the defense is attempting to do, is to tell the jury to turn a blind eye to the evidence, a deaf ear to the testimony, disregard logic, dismiss reason, and listen only to racial epithets and bragging accounts of hideous acts of misconduct, if any are true. And I pray that they are not. The point, Your Honor, as I was trying to make to the court earlier, was not to suppress the information. The information should be let out. The information should be publicly aired. It should be investigated. It should be examined carefully. Every single alleged incident to determine whether or not it did happen or did not happen. And Mr. Hahn, the City Attorney's Office, is present to accomplish that very goal. The point I make is that this is a murder trial where none of this is relevant. This is not the forum. This is not the forum. We need to keep our eyes focused on the evidence that is relevant to this case. And it's funny, I wanted to share with Your Honor something I saw, that occasionally these cartoonists come up with something that's edifying. The little child speaking to his mother watching television who says, what's the forbidden N-word they keep talking about, Mommy? She said, Nicole. I think that sums it up. I think that's what it's all about. And I think that we have to look carefully to the law in a lawyerly fashion and see if there's anything here that is legally relevant, that belongs in this trial, that this jury should hear about. The defense asks the court to take the escape hatch, if you will, Your Honor, of saying, let the jury decide. That's that great way of avoiding all responsibility and saying they can figure it out. Obviously, they can't. That's why we have rules of evidence. There comes a point after which you have to say, a jury's just never going to be able to winnow the wheat from the chaff, to get past this, whatever the this may be. And we've seen evidence of it in the past, and that's why the courts have ruled that there are certain things that just are so inflammatory or irrelevant or confusing or time-consuming that they do not come in, or unreliable or untrustworthy. That's really the bottom line of the evidence code. It just should not come in for much of those reasons. This is a case like that, and you saw in our brief references throughout history to various socially inflammatory issues of the day in which the court said, no, you don't get to bring that in, because all you will do is inflame the jury unfairly and cause them to look away from the evidence or read too much into it. And that is the problem we face with this evidence. Now, I find it very interesting that the defense, in its argument, never once really alluded to the evidence in this case. And it does highlight the very point that I'm trying to make, Your Honor, is that you cannot get away from the factual predicate if you are to base an intelligent ruling on what should come in on this case. You have to look at the facts that we have. And what are those facts? It is a fact that we have a number of police officers already at Bundy before Detective Furman ever got there. It is a fact that those officers saw one glove at Bundy before Detective Furman ever got there. It is a fact that Detective Furman was never alone outside around the evidence where he could have gotten a glove to take to Rockingham. And it is a fact that we have thumps against Cato's wall right where the glove appears. And if the defense theory is to be accepted, the thumps on the wall, which no one disputes occurred, that's an accepted fact, the thumps on the wall would have to have no connection to the appearance of the glove. That's ridiculous. Suspension of reason, suspension of logic. We also have to believe that Detective Furman is going to go and move evidence in a case where he doesn't know if there are eyewitnesses, he doesn't know if there are ear witnesses, he doesn't know if Mr. Simpson has an alibi, he doesn't know what the other officers have seen or done, among many other things. I can just go on and on with that. Ridiculous comes to mind.
Carpet fibers on the glove.
Right. Bronco fibers on the glove, on the Rockingham glove, and on the knit cap. I mean, these are things that Detective Furman could not know. This is way beyond the ken of anyone. And then, so to say that he's going to plant evidence when he doesn't know what it's going to turn up, let alone what the blood typing will turn up, and that will get me into yet another of the defense arguments, which is beyond silly, is you have blood evidence that comes back on the Rockingham glove to the defendant, Ron Goldman, and Nicole. Now, how can you plant the glove? What if the third party that comes up on that glove, in that blood, is someone other than the defendant? Then, hasn't Detective Furman completely messed up a murder scene? He has dumped a glove where it doesn't belong. It'll mean nothing when the blood evidence is finally analyzed, except point the finger at him. And by the way, Your Honor, while we're at it, if there's going to be evidence planted, why not plant a fingerprint? It's so simple. We don't have to worry about autorads and laboratory error rates and Dr. Weir and population genetics. Plant a fingerprint. So simple. No one thought to do that. If there was going to be evidence planted, I would think they would do a better job. But that's what's so silly about this. Now, the defense counters with the tortured logic that, of course, the conspiracy had to involve more And this is what you heard Mr. Ullman argue. This is another glaring problem with the argument. They would seek to bring in Mark Furman's statements to swipe the entire police department, at least every police officer out there at Bundy.
Swipe has a particular connotation.
As opposed to compression, that's right.
Yes.
I mean, to basically just to color the entire police department with the same brush that they do Mark Furman. Mark Furman makes certain statements that may or may not truly be his state of mind. It may be posturing for Laura McKinney. I don't know. But the unfairest cut of all is to allow them to bring in such evidence in order to impute that state of mind to other police officers. Lieutenant Spangler thinks that way. Detective Ron Phillips thinks that way. Detectives Van Adder and Lang, on the eve of their retirement due to collect their pension, are going to risk it all for this D2 they met that night? I mean, what, are they kidding? When I think about it in those terms and I think about the jury, I think, they're not that dumb. But the problem you have is not an issue of intelligence. It's an issue of emotionalism. It's an issue that is so inflammatory, I get upset when I think about it. I get upset on levels that go way beyond the case, way beyond it. Levels that take me back to when I was a teenager and believed that we were going to eradicate all this. We weren't going to have to be talking about this anymore. And here we are. I get totally unfocused. I get totally taken away from this case and onto my disillusionment, my discouragement, my frustration, my anger, that this insanity still exists. And this is what we invite to the jury. I'm a professional. I'm supposed to be able to not do that. And I have a hard time, very hard time. Now, the factual predicate that I urge to the court, I urge for a very specific reason. Counsel brought up the case of Anthony P. And in their moving papers, they also cited Mascarenhas. Now, it's interesting they cited Mascarenhas, Your Honor, because I was going to cite that in our moving papers, because I think that it's a case more helpful to the prosecution. And the reason for that is this. Mascarenhas makes it very, very clear that it is important for the court to determine when it weighs impeachment evidence to be offered, the nature of the inculpatory evidence offered. In Mascarenhas, the court took great pains to point out the fact that the prosecution case, as I recall it, the statement, was far from overwhelming. And in that case, it was a case of one-on-one credibility where a minor who was aspiring to become a narcotics officer was working undercover for a police officer. And he claimed that the defendant sold him codeine. And he turned the codeine over to the officer. And only his uncorroborated testimony, that was the sole testimony and evidence offered to prove the defendant's guilt. The court noted the fact that the defense proffered evidence of very probative value to show that this minor had worked for this undercover police officer on 2 prior occasions, and on both prior occasions were able to show that either 1, the minor fabricated false charges and proffered them to the officer to get a filing, or 2, that he actually, I believe it was, stole liquor in order to curry favor to get a customer to sell him drugs so that he could make a case, again, for the same officer. But the conduct and the logical nexus is shown there. Now, this is a one-on-one case, not ours. Our case is, if we took that Rockingham glove and threw it out, we'd have overwhelming proof of the defendant's guilt. I mean, that's how strong this case is. That's how little this case relies on Detective Furman. And I smile when Mr. Yeoman argues the point about Mr. Furman being such a critical witness. He knows better than that. Mr. Furman's not necessary to our testimony at all, because we have Detective Lang, Detective Van Adder, Detective Phillips, who all saw the glove in place. Detective Furman didn't even collect it. He saw it, he went and brought everybody back there, they all saw it, and then Dennis Fung collected it. We don't need Detective Furman. And he knows that. Detective Furman's view of whether he's an important witness or not has a great deal to do with the fact that he's trying to sell his role as a technical advisor in this screenplay to Mr. Flynn in the relevant passages. And by the way, I should mention to the court that the
defense neatly steps around the excerpts where he vehemently denies planting any evidence in this case, where he vehemently asserts he was doing nothing more than his job in this case. He said, you know, I've had many more interesting, exciting cases where I had so much more involvement and really did some work. Here, I was just out there just doing my job. I happened to see this glove, end of line. And I get all this. But then, if only because of the defense tactics, Mark Furman likely thought he became very important. That was his view, and it may very well have to do with the fact that they've decided to make him a key aspect of their case. Nevertheless, he's not important to ours. So we have a case that is so solid in its corroboration, all of the physical evidence, the DNA evidence on the Rockingham glove, on the defendant's sock. We have, and at the Bundy walk, we also have the hair and trace evidence of very powerful magnitude, showing the Bronco fiber on the hat, on the Rockingham glove. We have the blue-black fibers connecting the defendant's sock to Ron Goldman's shirt and to the Rockingham glove. We also have the defendant's hairs on Ron Goldman's shirt and in the ski cap. I mean, this is an extremely powerful case that requires no one witness for its proof, but many. Mark Furman, the least of which. Now contrast that with Mascarenas, where you have one defendant, one alleging accuser as the witness, with no physical corroboration whatsoever. And the court appropriately looked at that and said, here it is. Eric's testimony, and that was the minor, is the only evidence in any way tending to establish appellant's guilt. That testimony is totally uncorroborated, there apparently having been no effort made to supply Eric with marked funds for a transaction or to conduct a surveillance of his meetings with appellant. The prosecution's case was by no means overwhelming. There was not a scintilla of corroboration for Eric's testimony. That makes it clear that the focal point was the lack of corroboration and the fact that you have one-on-one case. Anthony P. is the very same thing. In Anthony P., you had the allegation made of sexual harassment by this girl against a guy in her class. I think they were both minors. I think they were both in high school. And it happened that he was African American and she was white. And the defense, it was a one-on-one case. There was no other corroborating witness, no physical evidence. And the defense sought to attack her racial bias as a basis for fabricating the charges, which, in that context, she could have done. It was physically capable for her to do it. And in showing bias and a motive to do so, there was an opportunity for her to do so that made sense that they should have been allowed to. In this case, contrast with this case, the defense in the beginning of this case has made many did a lot of posturing about how they would show that the glove was planted at Rockingham. Not only have they failed to do that, but their posturing has been exposed as baseless, as a sham. They can't. All of the evidence has proven conclusively and consistently that there was nothing planted in this case, that Mark Furman had no opportunity to do so, whatever his attitudes, whatever his beliefs, whatever he would have liked to have done. He could not do it. And the evidence has now demonstrated to this court that even under the third-party culpability analysis, People versus Hall, that where they say mere motive and opportunity is not enough to bring in evidence of a third party, in this case, we don't even have the opportunity. Assume you have the motive. So they don't even come close in this case. They have failed in their proof. If they wanted to get in this kind of evidence, the kind of proof they should have brought to this court, the kind of evidence that they should have been able to proffer is, I was at Bundy, I saw two gloves. Or I was at Rockingham, I saw Mark Furman run behind there and drop something. It never happened. No such thing ever happened. And in fact, what we have here, I mean, what's really kind of interesting is, for all intents and purposes, given the state of the evidence, Your Honor, and what the officers testified to at Bundy, Mark Furman may as well not have been there. I mean, when you look at it in an analytical sense, what they're looking to do is bring in a whole bunch of inflammatory material on a witness who had a very small part in this case, whose part they want to pump up as big as they can so they can make this issue as big as they can, to totally divest the jury from this case. And the admission of this evidence is, in essence, telling the jury, disregard the case. Look somewhere else. I know that I do want to remind the court of the January 20th ruling, January 20th, I think, where the court ruled in its written ruling concerning the admissibility of Kathleen Bell. And the court at that time said that it found it to be relevant because there was a juxtaposition of two things, and that is the indication of racial animus, that is the willingness to focus on an interracial couple, juxtaposed with fabrication of probable cause, that he would make something up in order to stop them. And it was the combination of those two factors together that made the court determine it to be relevant. Now, in this context, that now that we have seen that Detective Furman could not have planted any evidence, I would think that the standard would get even higher, but certainly it would not get any lower than that. In none of the excerpts that the defense has proffered have we seen any evidence that Detective Furman would fabricate or move evidence in order to frame someone because they are African American. And I wanted to read to the court in context the passages that Mr. Ullman has stated he feels are relevant for that purpose, because I think when you see them in context, let me see, proffer 4. Now, proffer number 4, of course, the court is aware that's again the transcript without a tape, and I will address, well, I'll address it now. We have a real problem with these transcripts without the tapes, Your Honor. The court has already noted the substantial variance. I had pulled out a few of the examples, but since the court is aware of it and the hour is getting late, I think it's probably unnecessary. But if the court would like me to...
It's a 6 o'clock day.
That's true, but you've been listening to us talk for an awfully long time.
That's what I'm paid to do.
That's true. Would you like me to cite them to you?
It's your record, counsel.
Okay. I think
But I have read the transcripts. I have listened to the tapes.
Right, then perhaps if I can just refer to it in the record so that the citation is in the record,
All right.
and I won't have to waste the court's time. I won't read it.
Actually, Ms. Clark and Ms. Roman will go to 5:30 today.
Okay. I'll be done way before then. I'll have that in a minute, Your Honor, just so I can put that cite in the record. But we do have a real problem with the accuracy. In a case where we are leaning on every word and every nuance and the context in which it's made to make arguments to a jury, it's extremely important that we have a very accurate transcript, one that gives the entire context in the most accurate manner possible. Obviously, we don't have that in this case. And as we were going through one of the, I think it was proffer number 12, it became very clear that the transcript prepared by Ms. McKinney and the transcript prepared by the defense were at variance, even as to one small excerpt. So we have real substantial problems with that, and with the inability for the people to ever accurately determine whether there was some license taken by Ms. McKinney, whether there were things left out that would have minimized or aggravated the passage. We'll never know, because she cannot remember what is not in the transcript, and that much is very clear. So with that caveat, proffer number 4 goes to transcript number 1 at page 33. Mr. Ullman cites this as an example of how Kathleen Bell is corroborated. Here's the entire passage. Like last night, I picked up this burglar. He's a known burglar and car thief. And he lived at 22nd and Western, and he's up in Westwood, in the residential area. I just threw him in the car, handcuffed him, took him to the station. How did you know he was a known car thief? He was a African American. He didn't belong. 2 questions. And you're going, where do you live? 22nd and Western. Where are you going? Well, I'm going to Fatburger. Where's Fatburger? He didn't know where Fatburger was. Get in the car. So under what did you arrest him? I didn't arrest him under anything. Just took him to the station, ran him for prints. Gave them to the detectives to compare with what they've got in the area. I'll probably arrest a criminal that way. Now, when you put all that in context, how is that a fabrication? What has he misstated there? He is stating to her, I have seen these things, I have heard these things, and my experience tells me something's wrong. We know that police officers act on these hunches all the time. Sometimes they're right, sometimes they're wrong, sometimes what they do amounts to an arrest without probable cause, in which case the case is thrown out. Sometimes it doesn't. But how does that corroborate Kathleen Bell? How does that show that he is singling this person out because of his race? What he is saying, in fact, is that he's looking at the way someone is behaving, at their inability to answer certain questions. He used a racial epithet in that context, but it certainly is a far cry from what Kathleen Bell said. It's a far cry from that. Proffer number 12. So it's clear, Your Honor. I mean, I'm reading that passage to you. In no way should it be understood that I think, or have ever thought, that anyone's race or gender should be something to be considered as to whether or not someone gets arrested. But I think that what I'm actually saying is I'm distinguishing this passage from Kathleen Bell, because that was one of the theories on which it's been offered today by Mr. Ullman as corroborative, and I don't see it as corroborative. And proffer number 12, again, now the problem with proffer number 12 is that this is clear acting. In this one, she is asking him, how would this officer react if this situation occurred? And then he's playing it out for her, and it's fictional. I mean, it is fictional. It's admittedly fictional. There's no bones about it here. And that's in tape number 1 at page 26. And the lead-in is they're talking about, McKinney says on page 25, missed a gun? No. This is not the one that's missing the gun. Oh, okay, I got you. This is the one that's the really competent one. Oh, okay. McKinney says, plays the female lead. Furman, you're in the 77th Division. I think the scene here, you leave them in. You make it summertime. Okay. It's not getting dark until about 8. You get the flavor. That's the whole passage, is we're talking about a scene. They're setting a scene. So we're not even talking about a fact here. Proffer number 35. In this context, we have the use, again, of a transcript without a tape. So we have the same problem we confronted with the other one. And this is the problem again. In the proffer, they say this passage occurs on page 11. Oh, excuse me, Your Honor. This is the one that's tape. Okay. Let me read the beginning of this passage so that the court can get the flavor, because again, the context is Mr. Ullman is saying this indicates a willingness to fabricate evidence or to plant evidence. Guy doesn't know how to drive it very well, like a stick shift, especially a Porsche. Big lulls where the car drops a little bit between shifts and jerks a little bit. So it starts out, and then it goes into some of the other stuff. And then continues, somebody doesn't seem to know how car drives too well. License plate's dirty and the car's clean. So, and then it goes into, we work the same 10 blocks, square 10 blocks every day, et cetera. There's a lot more there, but what's indicated, and I refuse to repeat the racial epithets, but what it indicates is not a willingness to fabricate evidence. It does not indicate a willingness to move evidence. He's talking about what he sees. He's not talking about a willingness to take a piece of evidence and incriminate someone because of their race. That's the issue that we have here. That's what the defense is trying to prove. And, of course, it's not appropriate as propensity evidence, but the point is, Your Honor, that even if it were, the passages cited by counsel do not prove that. That's the problem that we have. We have a capital case here. And the commission of perjury in a capital case that causes someone to get the death penalty, which Mark Furman could not have known whether or not that would happen at the time he was out there at Bundy. If you perjure yourself in a death penalty case causing someone to receive the sentence of death, you yourself are sentenced to death. He's willing to do that? There is nothing in here. There is nothing in these tapes, nothing in these transcripts that even comes close to what the defense is alleging in this case, let alone the conspiracy that they're trying to allege here with the code of silence. Now, and that brings me to another point, which is if the defense would to be allowed to bring in this code of silence argument, which would be vastly inappropriate, wildly inappropriate, then in response, would the people be allowed to bring in all of the good officers who've done acts of heroism, acts of courage, saved lives, to show the jury that that conspiracy stuff, has a lot to do with comic books and nothing to do with the evidence in this case, and there are good police officers out there too. I mean, you want to talk about a mini trial? We'll be here till 97 proving all this stuff. There has to come an end to this at some point, but we do have to use the rules of logic and the rules of evidence. And that's what the defense is trying to prevent. The very cross-examination previewed for this court by Mr. Yeoman shows you the way the admission of these tapes will derail this trial, and all without any basis in the evidence. When you look at the passages that I've now shown to the court in context, you can see that the conduct they're talking about bears no relationship to the conduct that they are trying to prove, which never occurred in this case, which could not occur in this case. I mean, that's what's so silly. Every time I get into arguing this, I think, but it couldn't happen. It couldn't happen. And I mean, that's really the bottom line here. We have a witness with a limited role whose credibility is at issue for the defense. The defense has sought to put it at issue with respect to planting evidence. We have proven conclusively and consistently, without any ability to refute it at all by the defense, that he could not do what they had been desperately trying to prove he did. Could not and did not. All right. So whatever he is, and as far as I can tell, none of it's good, but whatever he is, he couldn't do it. So what are we talking about? What are we going to bring in front of this jury? What is the theory of relevance here? What are we doing? We're going to bring in all of this extraneous stuff to impeach a witness whose credibility is established by other people with respect to this one point. And that's all we're doing. In other words, we're inflaming the passions of the jury, introducing irrelevant or at best collateral evidence to distract them from their duty as to an issue that is resolved by other evidence. That's all we're doing.
Isn't the issue broader? I mean, doesn't the language in Ray Anthony P., despite the unique facts of that case, aren't I required to allow broad latitude in cross-examining regarding bias, and in particular racial bias?
Your Honor, I mean, we have argued this previously, but no. Yes and no. Excuse me, yes and no. When there is an opportunity for a witness to have fabricated charges, when there is an opportunity for a witness to have done what they allege, yes, wide latitude should be permitted. And because in that situation, the opportunity combined with the motive adds up to something. You don't have that situation here, Your Honor. That's why Anthony P. is Anthony P. That's why Mascarenas is Mascarenas. In both of those cases, it is not inconsequential that it is a one-on-one case where the witness could very well do what they were alleging. And so the ability to prove a motive to do what they had the opportunity to do is an entirely different story. But that's apples and oranges, because in this case, the witness could not have done what they are attempting to prove with this evidence he did. That's the point. And so what we're really left with in terms of relevance, Your Honor, is collateral impeachment. The fact that we have something in the record does not, in and of itself, mean that rebuttal of that evidence comes in. For example, if I'm testifying in a burglary case and I'm a victim of a burglary, and I say, and by the way, the Yankees won the pennant in '55, and I'm wrong, does the defense get to rebut that by putting on extrinsic evidence that the Yankees didn't win the pennant in '55? No. I mean, that's an extreme example, but it makes the point. The fact that there is something in the record in and of itself doesn't mean we get to start slopping into the record extrinsic evidence, especially when it's so inflammatory. This evidence can be characterized no other way but incendiary and inflammatory. But it is definitely collateral. It is so collateral. It goes to impeach the question posed to Detective Furman as to whether he used a racial epithet in the last 10 years. And lo and behold, 9 years and 11 months before he made that statement, we have the bulk of the racial epithets being used. And I think that there is, to the extent that there is any relevance, the people have offered in their moving papers, and we reiterate the offer now, to stipulate that between 85 and 87, Detective Furman used the racial epithet in question. And that's the value of that evidence. That's it, Your Honor. That's it. It is collateral impeachment of a non-material point in the witness's testimony as to a witness whose testimony the court has seen. But again, this is not Anthony P. We cannot divorce the latitude the court gives to cross-examination from the facts of the case. To do that would stand every ruling on its head. Anthony P., the court in Anthony P. confronted one situation that is a vastly different situation than that confronted by this court. This court confronts a case with overwhelming corroboration, a case where there is no opportunity for the witness to have fabricated in the manner alleged. In Anthony P., there was all the opportunity, and hence when they had evidence of motive, it was improper to exclude it. A very clear-cut case. But the facts in the case have to determine the outcome in terms of the ruling. And so, yes, I do think that the latitude that the court permits in terms of cross-examining as to bias should be governed by the nature of the case, by the facts of the case, by what impact that witness has. Are we to turn a case on its head because a witness who has a small part of the case has a lurid past? Is the defense entitled to do that? Is the defense entitled to take a case, turn it upside down, turn the jury away from all of the evidence and say, look at that. Oh, but look at that. And that's what they'll do. That is what they will do. They already have the ability to do that to some extent. I'm asking the court to not let it go completely out of hand. Now, I think that every trial in California could be turned on its head in this manner. I mean, but I think it is clear, and I think that the facts in the Anthony P. case make it clear that we don't have the same situation. I know that the court is sensitive to the problems that are going to be engendered by the admission of such testimony. But it's not enough. It's not enough to split the baby, Your Honor. You know, when you split the baby dies. And sometimes, it has to be a little bit more. Sometimes you just have to come down on one side. And I submit to the court that this is one of those times. The defense does have the Kathleen Bell incident and Andrea Terry to back that up. The defense will have the opportunity, if they take the stipulation, to argue from the Calgic instruction. The people will have stipulated that Detective Furman lied. That's a lot. That's not a little. They will stand up with the Calgic argument, the Calgic instruction that the court's aware of, a witness willfully false, and they can argue everything they need to argue from that with the people's stipulation to the fact that he used that racial epithet. And that is the attention and the time, at most, that this issue deserves. But to turn this into the mini-trial of Mark Furman in the context of a murder case where his credibility has already been resolved as to the issue that the defense is interested in would be a travesty. We need to keep this jury focused. This is a tired jury, and a jury that has been here way too long. We've all been here way too long. And Mark Furman and the content of those tapes is the subject for another day and another forum, and it clearly will be. It's clear to everyone that it will be. This will not be swept under the rug. We have no fear of that. But this is not the place to take care of that. There is nothing good that can come of the interjection of a very serious social issue into a murder trial where it has no relevance. It is manipulative, it is crafty, it is cunning, but it is not proper. It is not relevant. It is not the way to prove a murder case, and it's not the way to defend a murder case. It is nothing but the very blatant attempt to inflame the jury, distract them from the evidence, mislead them, confuse them, and make sure that they do not look at the proof and the properly admitted evidence in this case. I want to remind the court, because we have heard all day about the defendant's right to a fair trial, the victims have one too. Nicole Brown's family deserves to see this case tried on the facts and the evidence that is relevant to the proof of the murders that were committed in this case. Ron Goldman's family has the right to see that this case is kept on track and that this evidence, that this jury is not distracted by inflammatory evidence that does not belong, that is not relevant to this proof of this case. This is a search for the truth, but it's a search for the truth of who committed these murders, Your Honor, not who Mark Furman is. That truth will be sought out in another forum. We have to search for this truth now, and I beg the court to keep us on track and to allow the jury to pursue that search for the truth based on evidence that is properly admissible in this case and relevant to that determination.
Ms. Clark, you say that the court shouldn't split the baby here, and that the court should come down on one side or the other. And you urge me, of course, to come down on the side that you would prefer me to land on. But in the same breath, you also say that you're willing to stipulate that Detective Furman used the term numerous times, and you're willing to agree to the 2.21 instruction that the witness will fear false. So aren't you splitting the baby there yourself in your argument?
In a sense, Your Honor, yes. See, it is my view that as reprehensible as the contents of the tape are, the evidence itself is collateral impeachment that is so inflammatory it should not come in. And under 352, I think we've made our position very clear that it should not come in at all. Yet I wanted to extend the stipulation because it is a fact that there was a statement in the record for which these transcripts are directly impeaching. And to the extent that they do directly impeach that statement by Detective Furman, that is the only arguable admissibility that I can see, is a stipulation that the word was used. The context in which he uses it is not relevant to this case. And his views on Ethiopia are not relevant to this case. But the fact that the epithet was used when there was a direct denial of that, I could see the court saying, well, you know, Ms. Clark, that's really kind of unfair. He did deny that under oath. He did. He did. And that is why I've offered to stipulate, because I think that is the maximum that should occur. But I think that it would be well within the court's discretion and a very appropriate exercise of that discretion to keep it out altogether, because it is collateral, it is inflammatory, it is not material. So I reasoned it that way. But I do not see that parceling out portions of these tapes to be played will will be fair. I do not think it will be fair. I do not think that really any of these tapes should be played for the jury, only because of the arguments that I've made to the court, because I think that we will wind up interjecting inflammatory evidence that really has no relevance here. That's... So I think that's, it was in that spirit that the people offered the stipulation, to the extent that the court thought that an admission should be made of the fact that the witness was impeached in some manner. To that extent, then, we offer the stipulation.
All right. Thank you. Mr. Ellman?
Yes, I could just have a moment.
You want a moment?
We're just starting. Just a minute. Just a minute.
Well, Your Honor, I certainly have to concede that Ms. Clark is not in an enviable position. Certainly, a prosecutor is never in an enviable position upon being confronted with really incontrovertible evidence that perjured testimony was presented by a police officer during their case in chief. But what we're seeing here is an effort to salvage what can still be salvaged from Detective Furman's testimony without conceding that this is a man in whom we can put no confidence whatsoever with respect to anything he said. This is a man who very early in the investigation of this homicide put himself right in the middle of everything. It was Detective Furman who led the detectives over to the Rockingham residence It was Detective Furman who discovered the Bronco parked askance, even though the photos didn't demonstrate that. It was Detective Furman who discovered the little speck of blood on the car door that provided the probable cause to jump over the wall and enter the premises. And of course, it was Detective Furman who finds the glove in a place that is totally inconsistent with all of the other physical evidence in the case, including alleged blood drops leading into the house.
What about Ms. Clark's argument that if Detective Furman had been motivated to frame your client, that perhaps a better place to drop the glove would have been in the kitchen or the bedroom or someplace that a little more logical place, since he had clearly had the opportunity to do that as well.
And he well might have if it turned out that that was an opportune place to drop it. We would contend that the location where it was dropped became an opportune place to drop it when he heard what Cato Kalin had to say. What you have heard was an argument that it was just presented facing the wrong way. It should have been presented facing this way to the jury, because what Ms. Clark is saying is, here are the facts. These are the facts. We know that the glove, that there was only one glove at the Bundy scene. We know that there's blood in the car. We know that those aren't facts. There aren't any facts yet in this case. The facts haven't been determined yet by the jury. And I could get up and present the closing argument that we're going to present to the jury, controverting most of what Ms. Clark said to you was facts. We don't concede those are facts. They're not facts at all. In fact, we have very plausible, credible evidence to controvert virtually every essential fact that is an issue in this case. So we don't have any facts. The facts are going to be determined by this jury. And Ms. Clark's argument to you is simply, well, we have such a strong, incontrovertible case that we know what all the facts are. So if you give this evidence to the jury, somehow this jury is going to go ballistic and ignore all the facts. I'm embarrassed. I have never heard a jury sold as short as it was in the argument that Your Honor just heard. I'm reminded of what Justice Robert Gardner once said about jurors are not some dithering nincompoops who were brought in from a pumpkin patch. We have confidence in the jury's ability to address the evidence in this case. We're not going to be getting up and saying, turn a blind eye to the evidence or turn a deaf ear to the evidence. We're going to argue evidence in this case. And among the evidence we're going to argue is the testimony of Detective Mark Furman, a central witness in this case no matter how you cut it. And I'm not surprised that there's a lot of backpedaling now about how, oh, he's not really a very important witness. What would we expect the prosecution to say when the witness has been proven to be a perjurer? This jury is sitting in judgment on this case simply because they bring some experience of life into the jury box. Because the events that they're going to be asked to sort out, the issues that they're going to be asked to resolve, will be assisted by their life experience. And the existence of 12 people who are brought in from the community to resolve these issues is really the central premise of our whole adversary system. And for us to prejudge the facts and to say we can determine what happened here, and what happened here is not consistent with what the defense is presenting, therefore the defense should be precluded from challenging the credibility of this witness, from showing his propensity to fabricate, it simply takes the case away from the jury. Why even have a jury? And that's certainly a legitimate question to ask in light of the argument that was just made. Why have a jury if we don't have any trust or faith in their ability to sort out the evidence and make their ruling based on the evidence in this case.
Well, why have 352 of the evidence code?
We have 352 of the evidence code to have a court make a determination of balancing probative value against the risk of substantial prejudice. And we're not afraid of the court making that kind of balance in this case. We are talking about evidence that is highly probative on several scores. It's not just probative on whether there's a likelihood that Mark Furman planted evidence. It is relevant on the issue of whether you believe any and all of his testimony from start to finish about every aspect of this case. It is relevant on the issue of habit and custom of police officers. It is relevant on the issue of 1101B in terms of plan, motive, and opportunity. It is relevant to corroborate Kathleen Bell. It is relevant for all of these purposes, and it is highly probative evidence. And it should not be excluded simply out of fear that jurors are going to become dithering idiots when they hear it. They're not. They'll be able to understand the argument that Ms. Clark made, and she's going to have her opportunity to convince this jury that they should still put some stock in what Mark Furman testified to in terms of how he discovered the glove, despite all of the reasons why we should disbelieve Mark Furman. Now, the argument that there's just no way that under these circumstances Mark Furman would have planted evidence or fabricated evidence in this case assumes that the only motive that Furman could have had to do this would have been because he wanted to frame an innocent man. But when you look in context of how Mark Furman explains what he does and how he testifies and how he conducts investigations and how he makes a decision of who to arrest, it tells you a lot about Mark Furman. And I find it speaking loud and clear in the context of that one example where he's playing with blood, where he's squeezing a scab to have fresh blood in order to justify an arrest. Now, if that isn't planting or fabricating evidence, I don't know what is. But in the mind of Mark Furman, it wasn't. In the mind of Mark Furman, here's what he thought it was. He said,
Counsel, I'm 8 feet away.
He says, it's putting a criminal in jail. It's being a policeman. So in the mind of Mark Furman, this kind of activity is justified if it's putting a criminal in jail. And it's perfectly consistent with everything he did, that's what he thought he was doing, even if he was falsifying evidence, even if he was testifying falsely in a number of respects in his testimony presented to this jury. Now, with respect to the specific incidents that we pointed to, that is items 4, 12, and 35, we invite the court to put those in context. Look at the broader context. I mean, what we were doing in this offer of proof was attempting to get right to the essentials that we believe conveyed the idea of what he is saying, what he is advocating, without a lot of extraneous material. But even putting these precisely in the context in which they were spoken, there's no question what he's saying in item number 4. There is no question but that what he is saying is if somebody in Westwood is black, he doesn't belong. And that provides a reason to stop them. And you can make up the reason later on to justify it. What he's saying in number 12 is about, in the context of Laura McKinney's question, don't you need probable cause when he describes stopping someone who is, as he puts it, a nigger? He says, probable cause, your God. Your God. That's Mark Furman's vision of his role in this process. And we contend there is ample evidence to point to in this record where he was playing God. And it's going to be up to the jury to decide whether that's what was going on or not. Item number 35, same thing. Nigger driving a Porsche that doesn't look like he's got a $300 suit on, you always stop him. I mean, let's not mince words. We know what he's saying. He's saying that based on racial considerations, a police officer can make decisions about who to stop, who to arrest, who to put in jail, who's a criminal, who the good guys are, who the bad guys are. I have been given lots of advice by my colleagues about responding to specific factual issues that Ms. Clark was raising, but I think to do that would detract from my main point. And my main point is that these are arguments to be addressed to the jury. These are not facts. We have a version that we want to argue to the jury, and the jury will determine the facts. And we all need to be reminded that we have a system where we put faith in the jury to determine facts, that we have confidence that they can hear evidence, even evidence that is ugly to hear, ugly to look at, that they can look it in the face, evaluate it for what it is worth, give it the appropriate weight, and then address the evidence and come to a rational conclusion in this case.
All right. Thank you, counsel. All right. Counsel, I think you have presented to me dozens of separate issues. Each one of these incidents is an incident that stands on its own, has to be evaluated on its own, that has to be weighed not only in the 220 credibility of witness context, but also in the context of the 1101B argument, the 1105 argument, and then the court has to make an independent 352 evaluation of each and every one of these individual items. So I'm not prepared to rule now. And I'm going to go back and reread In re Anthony P., because I want to see if I recollect Justice Johnson's opinion the way I recollect it, and if I recollect the facts that were before Judge Burke at the time that he made those rulings. I don't recollect the facts specifically. The interesting thing about In re Anthony P. is that was the first California case that actually, appellate court case that dealt specifically with this particular issue. And I want to go back and revisit that case before I rule, because I think that's clearly the guiding case in the issue that's before the court. The difficulty I have is that this is an unusual situation where you have somebody talking to somebody in the context of a screenplay. So this is not an interview of somebody for the purposes of the life of Mark Furman. This is in a context where somebody is trying to create a work of fiction. But it appears to me that there are instances where it is not role-playing. So the issue is, I have to evaluate each one of these items individually. And the quality of your arguments today, which I will compliment both sides on, has given me a lot to think about. And this is not something that I can rule upon from the seat of my pants. I need to sit down and look at each one of these individual situations and make the appropriate ruling. Unfortunately, that creates a time problem for us all. So why don't we address that issue at this point?
We would expect that Ms. McKinney would be the next witness. And so, having said that, we're mindful of what Your Honor just indicated about the need for time. And I'd like to balance that with the fact that we do have a jury that wasn't here today, and we want to get this case to the jury as soon as possible. Would the court care to indicate to us what is reasonable for you to render a decision in this case? Because once you render a decision, assuming arguendo that a number of these incidents are going to be appropriate, then we have to have the transcripts changed to allow what you let in, to have it redone, to cut the time down between them. And so there's a little bit of hiatus. Well, we have people standing by this afternoon in a laboratory to do that. So obviously we'll let that go. I mean, I understand. I did not know where we'd be at the end of the day. Mm-hmm. So we want to move ahead.
I'll show you how optimistic I was. I thought we'd finish this argument this morning.
Well, you did say, well, you were smart enough to decide by 11 o'clock we wouldn't. So that was good. Would the court care to tell us because that would really be the next witness if at all possible.
Well, here's the difficulty I have, Mr. Carkin. You've given me, 60-odd separate incidents. I need to go back and review the record to look at each one of these individually, perhaps even listen to the tape again. And this is not something that I want to do being rushed.
No, Judge, I want to make this perfectly clear. We're not rushing it. I was just asking so we would see.
But let me ask you this, are there other witnesses, Ms. Menzioni or any of those other witnesses that we could deal with over the next couple of days? Unfortunately, I have a commitment this evening that will limit the amount of time I have to work on it this evening.
Yes, may I have a moment to talk to my colleagues, Your Honor? There may be, the court's saying that you'd like probably until Thursday. Certainly, we understand that. Let me see what we have, and perhaps, may I get right back to you? Perhaps we can take, I know you want 5:30. Give us about 3 or 4 minutes. Would you do that?
Carlton, let's do this. Let me stand in recess until tomorrow morning at 9 o'clock. When you have your scheduling plans, let me know, and we'll make that public.
Let me see if I understand. You're going to let us talk about it now and come back and tell you?
Come back and tell me. You and Ms. Clark and Mr. Dard and Mr. Shapiro come back and tell me what your scheduling desires are. I'll just stand in recess, and then we'll select a date and time to reconvene, and we'll announce that.
Can we keep Mr. Simpson out here? You're going to
Sure.
I'll talk to him.
Sure. Okay.